I always want to start my jury. I'm really super excited, so I really appreciate that.
Big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
And then I just looked at the jury and sort of like, look.
Hey, if you want to come pop in and say,
You're a ray of sunshine, and I love what you've done on your YouTube channel.
Hello, 13th jurors. Hello, good morning, good afternoon, good evening, good day, whatever it is in your little corner of the woods. Hello. I am glad to see y'all. It is Friday Eve. It's Friday Eve. We got today and then one more day before the weekend. And I need a good, nice weekend. I am, it wasn't today a 4-day, or not today, but this week, wasn't this week a 4-day week too? And it feels like a 4-year week. This feels like the 12th day of the week, but that's okay. That's okay. Regina Crawford, happy anniversary. Happy anniversary. 7 whole months. Regina Crawford says, this is my happy place. This is my happy place too. I am glad. I'm glad that you have been here with us 7 whole months. 7 whole months. And it feels like 7 days or 7 years, depending on how you look at it and depending on what day it is. But that's okay. That's okay. Oh, hello, recovery addict folks. Hello. Just in time. We are just getting started. We are just saying good morning and hello and giving our morning / afternoon greetings. So y'all are just in time. Welcome. I am looking forward to today. I love speed trialing with y'all, and it has been, the mornings, I really do, like, mornings have been, a little bit, little tougher this week than what they normally are. But I will say this, like, it has been, like, I really look forward to getting here and starting the trial with y'all, and I love being able to do the speed trialing. It's so much fun. It's so nice to be able to go through all that with y'all. So I love it. Hello, RA. I keep forgetting to use these. Have a great stream today, Brandi. Thank you, RA. Thank you. I appreciate it, and happy anniversary. RA was one of our very first here at 13th Jury. He was one of our very first members, one of the OGs. So, and of course, huge friend and supporter. So, yay! I appreciate it. Payloa's mom. Squirrels eating radish train. Woo woo. I was trying to tell the nurse this morning about what I do, which is always like this weird thing. So I'm like, I was like, I have a podcast, but I also have a YouTube, and then trying to explain it to people. And they were asking me, okay, well, what are you covering right now? And I was trying to tell them a little bit about it. And I told one of the guys, I was like, one of the technicians or whatever, and I was trying to explain to him, and I was like, and then there was the squirrel eating a cheeseburger, and they all looked at me like I was crazy. But I mean, maybe they're right. So, but they didn't get it. But I was trying to explain to them, what it is, but whatever, they don't get it. Julie McBride, member for 5 whole months. Wait, where did that just go? I was going to show it. Where did it just go? Oh, there it goes. Thank you so much for all of your hard work. Thank you for being here for 5 whole months. Yay. I appreciate it. I appreciate your support. Yeah, they have to be here to get it. Yeah, I'm trying to tell, I'm trying to tell this technician about, I'm like, yeah. And then like the attorney got up and was like, oh, I'm sorry. Was there a, squirrel eating a cheeseburger under the car? And I'm like waiting for this big laugh like we all had. And he's looking at me like, yeah. So I think that they all think I'm a little crazy up there, but that's okay. That's okay. But I told them to come join us anytime. So if we ever see, so we might at some point, if they figure out how to do it, we might see one of my nurses or one of the techs pop in and say hi. And if we do, then we have to all say hi. But it didn't sound like they were going to. I don't think that they knew exactly what I was talking about when I was trying to explain what I do. So, that's okay. Oh, that's good. Yeah, I found saying I'm a content creator goes over much better than I like talking about murder with 50,000 of my closest friends. Yeah, that sounds a little bit more like, a little less like, hey, we might need to call in help for this person. So I'll start using that. All right, that is good life advice. I will definitely start using that. Let's see. Yo, mama, 8 whole months. Happy anniversary to you. 8 whole months. I'm glad you're here. 8 whole months. 8 whole months. Which what comes after 8 months is 9 months. I know y'all didn't come here to math, so I'm just going to go ahead and tell y'all. 9 months comes after 8 months. Which means we're knocking on the door of a year, which is crazy. I can't wait to see who the very first 1 year anniversary is going to be. That's going to be so fun to see that too. So every month when we get the first the first 8 month anniversary and we had the first 7 month, the first 6 month, that's always really cool. So, we've got the 8 month people coming in now. We have not had a 9 month yet. I can't remember exactly what day it was that we, I have it written down somewhere, but I'm curious to see, who the first 9 month is, and then of course who the first year is. That's gonna be fun too. I know a lot of people are saying that you're getting kicked off. Apparently, if you have ad blockers on your YouTube, it has gotten to where it will mess with stuff. So if you have an ad blocker on, that might be the reason you're getting kicked out. True Crime Ranch told me that yesterday. She saw that on Iked Mel's channel. He had said something about it. So maybe that's part of it. I don't know, but YouTube's been kind of wonky lately. So, oh, look who decided to join us. Hello, sweet girl. She just came in and laid down. Let's see. Look at that little thing. Look at her little self. She just came in and plopped on down. I had originally put on dog TV. For her, when I leave in the mornings, I'll put on dog TV. It has dogs running through the, waves in the ocean and stuff. And it has music that's supposed to calm them. And I swear to you, I put it on YouTube, and normally it's the 24-hour, video, and then it'll just go on to another one when it's done. And I guess because I put it on for her so much, when it ended, I guess I was towards the end of it and I didn't realize it because, I'm gone for a few hours in the morning. And when I came back, she was watching one of my streams, and I was like, I don't know how you did this. I don't know how she managed to have one of our old streams on, when dog TV went off, because I put it on YouTube. So, I mean, technically, I guess it could have just come to, started that one after it. But I thought it was pretty funny. I was like, oh, I see you. She missed her mama and she wanted to watch. She missed her mama and the 13 jurors. Brooke, hello. Been lurking all week, but still here. I am glad you are lurking and I'm glad you're here. Happy 7 months, Brooke. Glad to see you. Glad to have you. Oh, Breezy had a, where did this just go? Breezy, where'd you go? Breezy, where'd you go? Where'd it go? Breezy had an 8 month. And I just lost it. Breezy? Where'd you go? Hold on, I gotta find it because I want to show it. I like to show that. Oh, there it goes. Breezy, happy anniversary. 8 month party train. Whoop, whoop. Love a good party train. Love a good party train. Yeah, she wanted her mom. I thought that was adorable. Also a little creepy, but more adorable than creepy. It's a fine line between adorable and creepy. And she was definitely more on the adorable side. and a little less creepy than adorable. So it worked out good. It's Mama TV. She was sitting there like this, like perched up on the edge of the bed watching it. So she was all about it. Okay, so I will give y'all, I know we've been on the count waiting to get to 15,000. We are at 14,823. So we had 23 more subscribers since we ended yesterday, which is awesome. So we are getting so close. Less than 200 now from 15,000. I think that's the coolest thing. Like, who knew that our little family would grow, so much? I think that's the coolest thing. I'm so excited about that. It's, who knew? I think it's so cool. All right, so here we go. We are going to be going into day 5. I spent most of my morning reading a book about New York history, which is really interesting. Not all New York history, mostly just about the Astor family and their fortune and stuff. Very interesting stuff there. Very interesting family. But anyhow, I digress. I spent most of my morning reading, so I did not keep up with a bunch of the updates. So I figured we'll go through all of this together. So I don't know a lot of the stuff that has happened this morning. I did happen to see that they were bringing in the DNA stuff, some of the DNA stuff that they had talked about, but that's all I know. That's the only thing that I've actually seen. So we're going to go through all of this together. Dallas, one of our amazing mods. Hello to entire 13th Juror family. I'm on the Lurky Lurk from NYC this week. Love y'all. Oh, that's cool. NYC. And I was just talking about reading my New York City history stuff too. Very cool. Dallas has been a member for 8 whole months, and of course is one of our amazing mods. Love our mods. Yay! Hellcat says, I'm all in my feels listening to you be so happy and excited about stuff. You're a beautiful soul. Thank you so much. I am happy and I am excited about stuff, and I feel good today. I did not feel great yesterday. I feel good today. So it's a good thing. It's definitely a good thing. Let's see. There is also, yes, Dreamlander, there is a Karen Reed hearing at, is it 1:30 today? I had 2:30 written down. But I could be totally wrong because that is known to happen. Let me see. Let's see. Oh, I'm in the wrong month. Karen. Oh, actually, I didn't have 2:30. I had 3 o'clock written down. So I am way off. So we can take a peek at that too. I don't expect it to last very long. But of course we do want to know, what's going on with that as well, since we've been following it so closely, and that's what the podcast is on. So we'll definitely take a look at that as well. I know that her attorneys are in trial and cannot be there. I think the one, I think Unetti can be there, I think, but I don't think Jackson can. So, but regardless, we'll take a look at that and see too. All right, so there's also a hearing to see if Pryor gets let off of Chad's team. Yeah, I saw that there was a, she gone. Lucy's like, I'm not cut out for the spotlight this morning. I saw that there was a motion filed to go against that. So I'm curious to see what happens with that too. So we got, this has just been one of those weeks where we have so much to have to watch and catch up on. So we'll try to do it all. Try to do it all around here. We'll just be hopping around all courtrooms all over the nation. All right, so we are going to get started on let's get it pulled up. This morning for Michelle Troconis trial. day 5. First thing in the morning. All right. Let's get this show on the road. Oh, Lucy gone. I want to hide her. All right, y'all ready? Here we go.
Also, the court will advise the jury that today we are adjourning at 3 o'clock.
Yes, Judge.
Okay, thank you. We'll stand in the recess.
Oh,
All rise. This honorable hears for now stays in recess.
okay. Actually, that's good if they're adjourning at 3, because then we can watch the other stuff that's happening with the rest. Like, we'll watch the other 2 hearings since they're adjourning early. So that works out good for us. And they're already... All right, here we go. Let's see.
Please be seated. Thank you. Have you concluded your discussions, Attorneys McGinnis, Joan?
Good morning, Judge. Yes, we have. I believe the defense is signing the stipulation right now. There's 2 stipulations, Your Honor, relating essentially to chain of custody issues with
We're gonna
respect
do the
to
1.25.
evidence that Detective Riley seized and was subsequently submitted to the state laboratory. I'll just indicate that the defense has asked that the state ask a few clarifying questions on direct examination of this witness, essentially indicating that most of these swabs taken by Detective Riley were not tested for confirmatory blood, human blood testing at the laboratory, that they were simply sent for DNA analysis. And I indicated to counsel that I didn't have an objection to asking those questions. The witness who ordinarily would testify to that is expected to testify sometime next week or so, depending on how the schedule goes. But just to short circuit it, I'm just going to ask those questions.
So what the court will probably do is ask that the stipulation be presented to the court after the state's questions.
So, Judge, if I may.
Unless there's cross-examination.
Well, there's another reason maybe not to do that. It's, and if I may interject, I think this is why we're agreeing to this. What this is basically a flow chart. We're skipping some of the chain of custody material. So,
Oh, thank gosh.
To facilitate that flow, it may be necessary at least to put it up or to mention it beforehand, only because this witness is going to be testifying to testing things that came from, and makes it sound like it was picked up at the garage and whisked to her office, when instead there are a couple of intermediate steps that would need to be clarified. We don't need to do it in cross-examination. If it goes in this way, at least it explains that skipped step, if you will.
So you have the flow chart, correct?
It's not in a chart form, but it's essentially that. Yeah.
My intention, Your Honor, was essentially to publish the stipulation with each exhibit so that this was identified as State Police 12. It was submitted to the state laboratory and re-designated as laboratory submission.
Okay, so if they're doing
example,
stipulations,
and then
that's
you
going to
please
be
tell us the results
amazing
of
for
two,
us.
Right, just sort of go through it that way. And so I'm going to publish the stipulation as we go along. If the court would like to review it in advance. I'm happy
So, like,
to
instead of
send that
having
now.
14
Well, what the court has to
people
do is explain
that
to
have
the
gone
jury
through the
what a
chain of
stipulation
custody,
is.
they're going to
And
skip
so what the
forward.
court will do is
Anything we can skip.
wait for counsel to indicate that it may be an appropriate time for the court to explain what a stipulation is.
And I'll note we've signed
We already
the
know.
stipulation.
We're experts.
There's 2 stipulations. There was one other, I think it's just that there was one additional remark, that it's not just that several of these things were not tested, but that some were tested and were negative for blood. And the reason this is important is the stipulation uses the same name that the police used, and it often mentions Castlemeyer and luminol. And of course, this goes back to whether, my concern about it being in it all, but since it is, for most of these, there was never a confirmatory test, and then some that were tested came back negative. It would give the false impression, perhaps, to the jury that when there was DNA, that it was blood DNA, when in fact it was skin cell DNA, even though it was taken from something called a blood-like stain that tested positive for KM. But it's to get that clarified because of the reference to those reagent presumptive tests.
Well, are we ready to proceed?
Yes.
There's just one other thing I want to put on the record, and the state did share this with us, and I just want to raise it now so it doesn't happen in the future. The witness who was here yesterday had been instructed specifically by the state not to mention a firearm. So this is a witness who then apparently deliberately violated an instruction. And that's why I wanted to let the court know that if we have concerns about any other witness, we would need to have either a sidebar or a discussion outside the presence of the jury. Perhaps if the court had admonished the witness, she wouldn't have disobeyed the instructions by the state.
Well, the court would not have known that the state instructed the witness not to mention firearms.
You remember
Your Honor,
they
if I can just
told,
be heard on that. I don't think that Ms. Almeida deliberately violated any sort of instruction. The question was phrased by me, I think, a little inartfully. I had not appreciated the fact that she had mentioned the gun when asked whether or not, what she had relayed to the police. I was expecting to just hear that there was a missing mother, she apparently misunderstood, and so it was completely inadvertent. As the court knows, what we're doing here is a tightrope act, and these things are going to happen from time to time. But yes, the witness was instructed not to mention the gun, and unfortunately, what happened. But I don't think there was any sort of deliberate, attempt to circumvent the instruction by the state. And I'll also just add, Judge, that I had actually offered for Ms. Almeida to be present in the room during the offer of proof and the argument on the uncharged misconduct, and the defense did not want her present. And I specifically indicated that I would hope that she would be present because in case there was an issue. So perhaps that is another way to handle things in the future, that the witness could actually be present for some of the arguments so the witnesses understand exactly what the scope is. And I indicated at that hearing that I would not be eliciting evidence of the firearm. So I just want to say that I think it was completely inadvertent, and that's all.
Thank you. Are we ready for the jury?
how dare you disobey? How dare you disobey? I love me a 5-second skip. Woo! Love it. Put that on my gratitude list. Alrighty. Who we got here? I like her shirt.
Do you solemnly swear or solemnly
I like her whole getup.
as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Can you please state your name and spell it for the record?
Kristen Madel, Kristenmadel.
And your affiliation?
I work at the forensic lab.
Ma'am, you may be seated. Thank you.
Good morning.
Good morning.
Ms. Madel, who employs you?
The State of Connecticut Forensic Science Laboratory.
I still
Where's the
can't find
Forensic
my
Science
comments.
Laboratory located?
It's located at 278 Colony Street in Meriden, Connecticut.
How long have you worked for the State Police Forensic Laboratory?
Next week will be 20 years.
What is your position at the lab?
I'm currently a Forensic Science Examiner 2 in the DNA unit.
What are your duties at the laboratory?
My main duties are to extract DNA from items of evidence that may contain biological stains or material. I perform analyses. I develop a DNA profile when possible, write reports, and testify in court when necessary. I also am a supervisor in the DNA unit, so I supervise 2 FSC1s or Forensic Science Examiner 1s within the unit on their daily duties. I am the quality control coordinator for the DNA unit also, which means that I make sure that all the reagents and consumables that we use in our DNA testing process are checked before they're put into use for casework. And I'm also the contact person for missing persons cases that require DNA testing.
Smart cookie.
I'm going to hand you several exhibits that have been marked for identification in states 18 through 28. I'm just going to show you States Exhibit 18 first. What is States Exhibit 18?
This is my CV.
And I have provided a copy of that to Attorney Sean. I'm moving its evidence at this point.
Can I just see which one it is, please? It's referenced by number, so if I could just look at the... No objection.
Is that States 18?
It is, Judge.
States 18 will be admitted as a full exhibit.
Arlene's late. Detention.
I'm also going to hand you States 19 through 26 for identification purposes only, and just ask that you hang on to those for now. And if I just have a brief moment with Attorney Schoenhorn.
Oh, that's fine.
Now, you mentioned that you work in the DNA portion of the laboratory. Can you tell the jury what is DNA?
DNA stands for deoxyribonucleic acid, and it's the hereditary material found in a cell that makes you who you are as an individual in an organism. DNA is passed from parent to child, where you get half your DNA from your mom and half your DNA from your dad, and nuclear DNA is unique to an individual, except for identical twins.
Before you proceed, ma'am, there's an interpreter, so we would ask that you would just slow down your delivery so that the interpreter can interpret accurately.
Okay.
Thank you.
Slow down all you want, honey. We can speed you up.
What are some sources of DNA?
You can get DNA from cells in your body. So cheek cells within your mouth, blood, saliva, body fluid such as semen. There's DNA in the roots of your hair, nuclear DNA, bones, and teeth.
What is the purpose of DNA testing?
DNA testing is a forensic tool of comparison. So we want to try to include or exclude a possible person as being a contributor to that evidentiary profile. So we develop a DNA profile from a known profile and the evidence, and we compare those to see if they match.
How do you obtain a DNA profile?
We use standard protocols and procedures that are accepted throughout the United States and the world. First, you want to get the DNA out of the cell. So you open up those cells and extract the DNA. Then we want to see how much DNA we have. So we want to quantify that DNA. After we know how much DNA we have, we want to go make many more copies of that DNA. So we amplify it, think of a photocopier. And then after that, we want to separate those DNA types so we can develop a DNA profile, which is represented by a series of numbers.
Approximately how many DNA profiles do you typically compare to evidence in a given year as either a primary analyst or a technical reviewer?
Oh, thousands.
Does your equipment also have the ability to tell you whether or not one or more of the contributors to a DNA profile are male or female?
Yes.
What is a mixture?
A mixture is when you have a DNA profile that is more than two or more people contributing to that profile. So to give an example, like I said before, you get half your DNA from your mom and half your DNA from your dad. So if your mom gives you one type and your dad gives you that same type, you might only have that one type represented at any specific test site. If your mom gives you one type and your dad gives you a different type, you would have two different types at that test site. So if there's ever evidence of 3 or more types at a particular site, that's evidence that it's more than coming from more than one person.
Are you familiar with the term trace DNA?
Yes.
What is trace DNA?
Trace DNA is DNA that is left behind when it comes in contact with a person or an object.
Is it possible to touch something or come in contact with something and your DNA not be detected during testing?
Yes, that is possible. It depends on how long you touch something, how hard you touch something, what the substrate is, and how much DNA can get left behind.
What is primary transfer?
Primary transfer of DNA is when you transfer DNA from a person to an object or a person to person.
What is secondary transfer?
Secondary DNA transfer is when DNA can be transferred from a person to an object, from a person to an object to a person, from a person to an object to an object. I don't know if I said that one already. But yeah, those are some examples.
To a person, to a radish, to a squirrel.
And in doing your analysis, you reach certain conclusions. Is that correct?
Yes, but after we make a comparison between the evidence and a known profile, we would have a conclusion, correct?
I'd like to talk to you about different conclusions and what those mean so that the jury is clear. When you reach the conclusion included, what does that mean?
An included conclusion would mean that the types in the known profile are present in the evidentiary profile where there are results.
What does the conclusion cannot be eliminated mean?
Cannot be eliminated is a conclusion where you have a partial match between the known types and the evidence where results are detected.
What does the conclusion eliminated mean?
Eliminated is when the known types are not present. Some of them or all of them are not present in the evidentiary profile.
What does your conclusion consistent with source mean?
Consistent with source is when the known types are present in a single source profile at where results are obtained.
And what does the conclusion consistent with contributor mean?
Consistent with a contributor is also a conclusion where a person's types are present in a mixture profile where there's results.
Are you familiar with the acronym STR?
Yes.
What does STR stand for?
STR is the actual type of nuclear DNA testing that we do. It stands for short tandem repeats. And this is type of DNA testing that is used throughout Connecticut and the world. And you are basically looking at length variant repeats. So at any particular site, like I was talking about before with the different types, those types are represented by a number, and that number is because of the number of repeats at that site. So you think of it as a train, and every train has a engine car and a caboose, but the number of train cars in between those are the repeats and the different lengths. So I may have 15 train cars in between, but you may have 16. So those are what we're looking at.
She explains things well.
Are you familiar with something known as STR mix?
Yes.
What is that?
That is a software that is used to help the DNA analyst interpreting the DNA profiles.
Are you familiar with the term likelihood ratio?
Yes.
What is that?
A likelihood ratio is the evaluation of the weight of the evidence under alternate hypothesis. So that's the statistical weight that we give to a conclusion that is at a positive association. So you have some kind of weight to what that conclusion means.
This is what they were arguing over
At the
about
laboratory
how
itself, what types of steps do you take to
not
ensure
being able to
there's no,
test that.
Contamination from sample to sample?
Sure. We always wear lab coats, masks, gloves, hair nets when we're processing samples in the laboratory. We use bleach and UV light to clean our surfaces, and we have separate testing spaces for our known profiles versus our question samples.
When a case gets assigned to the laboratory, does it get a particular case number?
Yes.
I want to direct your attention now to a laboratory case number entitled DSS-19-002984. Did you conduct DNA analysis under this laboratory case number?
Yes, I did.
And was this laboratory case number associated with the New Canaan State Police investigation into the disappearance of Jennifer Dulos?
Yes, it was.
And in terms of doing DNA analysis, what do you need as a forensic scientist to do a comparison between a particular person and a DNA profile found on a piece of evidence?
I'm sorry, can you repeat the question?
Sure. So how do you do a comparison between a particular person and an item and a DNA profile that you find on an item of evidence?
Well, you have to develop a DNA profile for both of those. You need a known sample from that individual or person that you want to compare the evidence to.
You mentioned a known sample. What is a known sample?
A known DNA sample is a sample taken directly from a person that you know it's coming from, that source. Typically swabbing up the inside of your cheek swab.
Are you familiar with the term pseudoknown?
Yes.
What is a pseudoknown sample?
A pseudoknown sample is a sample that's typically a piece of evidence that you gather from a person that you think their profile would be on, and it would be a single source because you can't collect a buccal swab from that person. So a good example of this would be a toothbrush. You should be the only person on your toothbrush, and then we could develop a DNA profile from that to use for comparison.
In connection with this particular case, did you receive known DNA samples from several individuals?
I did.
And perhaps I'll just read them. Did you receive known DNA samples from Fotis Dulos, Michelle Troconis, Lauren Almeida, Howell Gumieni, Petros Dulos, Theodore Dulos, Christiane Dulos, Constantine Dulos, and Noel Dulos?
I did.
Now, when a known DNA sample is processed at the laboratory, who typically processes that sample?
Typically, the knowns are done in a separate section of the lab to keep them separate from the evidence, and we have a separate section of people who process those knowns. I actually processed the two from Fotis Dulos and Michelle Troconis myself because I believe it was a sample that needed to be processed quickly, so I did them by myself and didn't wait for someone in the known section to do them.
So essentially, the ordinary process is a known DNA sample is extracted by someone else in the laboratory, and then you ordinarily review that data and compare it to the samples found on the evidence. Is that correct?
Correct. Yes, it's done in a different part of the lab. It goes through the same process. It's analyzed, it's reviewed, and then that final profile is given to me so I can use it in comparison to the evidentiary profiles that I have.
You mentioned in this case that you personally did the extraction for the known DNA samples of Fotis Dulos and Michelle Troconis. Is that correct?
I did, yes.
Did you do any other extractions of what would be considered a pseudoknown sample?
I did. I processed the toothbrush.
Were you able to generate a DNA profile from the toothbrush?
I did.
Oh, oops.
Your Honor, perhaps this would be an appropriate time to present the stipulation.
Yes.
Thank you, Sandra
This has
Oliver.
been,
I choose you.
marked as State's Exhibit 27 and 28. 27 is entitled A Stipulation Regarding Evidence Seized from 69 Wells Lane in a 2014 Range Rover. And State's Exhibit 28 is entitled Stipulation Regarding Evidence Seized from Jennifer Dulos' Chevy Suburban.
Thank you. Ladies and gentlemen, what the state and the defense have agreed upon is contained in what is called a stipulation. It is signed by both parties. A stipulation is an agreement as to certain facts.
Thank you, Holly Mack.
So you will have an opportunity at the appropriate time to review those stipulations. Again, those stipulations concern an agreement between the state and the defense as to certain facts. Do you wish to publish it now or no?
I'll publish it as we proceed with the direct run.
Thank you.
Thank you so much, Holly Mack. JM,
Are you
5 whole
familiar with
months.
something known as a parentage analysis?
Happy anniversary.
Yeah, parentage comparison is when we compare to see if a parent can be the possible donor to that child's DNA. So we do a comparison and then a statistic to show the frequency of people who could be a parent to that child.
And did you do a parentage analysis in this particular case?
I did. I compared the toothbrush to one of the Dulos children.
If I could just approach.
Oh, Evangeline Light, get you 5 memberships. Thank you so much. Thank you. Let me see who they went to. Michelle Johnson. Oh, I can't see. Blackbird Squeaks. Shelly. Laksu. P. Brown. Gifted memberships.
This is State's 29th for identification, Your Honor.
Thank you.
Thank you, Evangeline.
Can I just look at it quickly, please? Thank you.
Dreamlander, thank you for super chat.
By agreement, Your Honor, I think State's Exhibit 29 can become a full exhibit.
States 29 admitted as a full exhibit.
Can you State's Exhibit 29?
Yeah, I like being able to hear them. I boost the sound so we can hear them, but we also hear like their aggressive typing
You
and their
indicated that
whispering.
you've done an analysis of the profile that you obtained from the toothbrush to Petros Dulos, is that correct?
Yes, this is the report I generated with that comparison.
And can you tell the jury what your conclusion was?
My conclusion was the source of the DNA profile from the swabbing of the electric toothbrush is consistent with being a parent of Petros Dulos. The expected frequency of individuals who could be a parent of Petros Dulos is less than 1 in 8.1 billion in the general population.
Now, when evidence comes to the state laboratory, is it given a submission number?
Yes, when a submitting agency brings any evidence to the lab, it's given a unique case number, which we discuss as this DSS 19-002984, and then each piece of evidence is then given a number underneath that case number.
And what was the submission number for the toothbrush in this case?
Submission number 7.
Lucy's back.
Now, ordinarily, if there is swabs taken by a police department and submitted to the state laboratory for further forensic analysis, where's the first stop for those swabs?
If there's just a DNA request, those swabs would go to the forensic biology unit, where they would prep those swabs for the DNA unit. So the person would just basically cut the cotton swabs off the tip and put them in a tube for DNA.
And are you familiar with someone named Christine Roy?
I am. She's a forensic scientist in the forensic biology unit.
And she has since retired, is that correct?
That is correct.
But she did most of the cutting in this particular case, is that correct?
From what I recall, yes.
She reminds me of somebody. Does she look like one of our old witnesses
And
or
when
something?
a swab is cut off by forensic biology and submitted for DNA analysis, does that get an additional submission number?
Or an
Yes, it gets
actress?
what we call itemized. So if the parent item is number 1, then when they cut that swab off, they'll designate it as either a 1-1 or a 1S1. Since it's been 5 years, the evidence nomenclature has changed a little bit, but it gets a sub-item of that parent item.
Doesn't she look familiar?
And many of these swabs that were submitted were described by the state police as being KM positive. Are you familiar with that term?
Yes.
What does that stand for?
KM is Kasselmeyer, is a chemical screening test for the presence of blood in a sample.
Many of these swabs, though, were not tested at the laboratory for confirmatory blood. Is that correct?
That is correct.
And some actually were tested additionally by the laboratory and came back negative. Is that correct?
For confirmatory testing or KM?
I believe for KM.
There might be some results in here that we did do KM testing on some samples. I can't recall exactly, but.
Okay. And if I just have a moment to reach over.
Twinsies. She looks like an actress. I think she does. She looks so familiar. I can't think of who it is.
And
Yeah.
just to be
So
clear,
close.
most of these swabs were not confirmatory tested for blood either. Is that correct?
Correct. Confirmatory test would be a separate test than KM. KM is a screening test.
Young Sally Field. I could see that.
Now, you've indicated that you did analysis
she's
in this
gone
case.
again.
Is that right?
Yes.
Okay. I'd like to talk to you about some of the results, if I could. If we could just pull up the first one, please.
I think it's, hold on, 14,829. So 171.
Your Honor, I'm publishing on the screen
I didn't come here to math.
a photograph which is found in States Exhibit 9, Folder 3, specifically photograph 2.
I could see Katie Holmes too.
And I'm just going to publish the stipulation at this point. State Police Exhibit 9 was seized from 69 Wells Lane by Detective Riley on May 25th, 2019, and identified as 2 swabs from the scene, exterior handles of the mudroom back door, and was subsequently submitted to the Division of Scientific Services and designated as submission number 2. And Ms. Maydell, just for your benefit, this
She
is
does
referred
look
to
like
as being
Mary.
a SUP 1, SUP 9, and SUP 18. Could you tell the jury what your conclusions were with respect to submission number 2?
Sure.
Ruffle those papers right in the
So
microphone.
for the first report that it was reported in is supplemental DNA report, and it is item 2S1 was the swabs from, quote, exterior handles of a mudroom back door. The results are consistent with the DNA profile from item 2S1 being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 2S1.
May the interpreter request that you speak a little bit slower.
Sorry. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Fotis Dulos could be a contributor to the DNA profile from item 2S1.
All right, so that swab
what
is
about the defendant?
inconclusive.
Michelle Troconis is eliminated as a contributor to the DNA profile from item 2S1.
And
Could we have a sidebar for a moment, Your Honor?
No.
Yes.
Sidebar. Take a shot, do a squat. This is going to be one of those things where she's going to go through all of those things. This is like where I was saying, like, how I wish they would just show us the chart and be like, this one was here and this one was here and this one was here, and then move on with our lives. But that's not the way they do it. We have to, it's like pulling teeth around here, fellas. It's like pulling teeth. That's okay, because we got a 5-second skip button, and that's what I'm grateful for today. Among other things. That and a lot of sleep yesterday.
Obtained from that calculation.
Let's see. All right, here we go. Audio, friends, audio.
Obtained from that calculation is above what our elimination range is, but below what our positive association is. So therefore, we cannot reach a conclusion for that particular comparison.
And eliminated?
Eliminated is when the likelihood ratio is below our positive association, so we eliminate them, a negative likelihood ratio.
And just staying with lab submission 2S1 specifically.
Testimony is clear to the jury. Just using a narrative
you.
form,
You do you,
Ms.
boo.
Maydell, Inconclusive means you can't tell, correct?
Correct. I can't eliminate and I can't do a positive association. There's no conclusion can be made for that particular comparison.
Thank you. Any questions based on the court's question?
Badges.
Noted.
Thank you.
Staying with item 2S1, directing your attention to DNA supplemental report number 9. Did you do additional analysis with known profiles?
Yes, I made big one, sorry.
That's right. I know it's a lot.
Catherine, let me look that one up. Amy Lee.
So the conclusion I made in this report was 2 different knowns. So the conclusion is the same as the results are consistent with the DNA profile from item 2S1 being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Fotis Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 2S1.
So inconclusive
The
for the
results do
youngins.
not support the hypothesis that Lauren Almeida is a contributor to this profile. Assuming
Not the
2
nanny.
contributors, Lauren Almeida is eliminated as a contributor to the DNA profile from item 2S1. And also Pavel Gumeni is eliminated as a contributor to
So
the
that's the
profile from
Tacoma guy.
2S1.
So Tacoma guy and the nanny are out of there. Not them on that one. Dino 420, thank you. Mod
This is
love and
paragraph
choo-choo.
2 of State's Exhibit 27. State Police Exhibit 10, which was seized by Detective Matthew Riley from 69 Wells Lane on May 25th, 2019, and identified as 2 swabs from the scene. The interior handles of the mudroom back door was subsequently submitted to the Division of Scientific Services and designated as submission number
You can show your
3.
love to the mods too. We have a tip jar for them since they do.
This is in DNA supplemental report number 1. Can you tell the
So
jury
much.
what the results of your analysis were for that particular item?
Do I have, it's supposed to be State Exhibit number 27, you said?
Ms. Madell, it'll be DNA supplemental report number 1, which is in front of you. State's Exhibit 27 is the stipulation that I'm reading.
Oh, okay, sorry. Was lab item number 1?
Lab submission number 3.
3, sorry. Yes, sorry, found it. That was bag with 2 swabs, and the sub-item was called swabs from, quote, interior handles of mudroom back door.
And what were the results?
For item 3S1, there was no DNA profile detected.
What does that mean when no DNA profile is detected?
There just was not enough
it was
DNA
a
there
radish.
to detect a profile, so I have no results.
Could have been a radish, could have been a cheeseburger. We'll never know. Julie F is going to Walmart. We haven't gotten to
Publishing to the
Walmart in
jury
this
on
trial
the
yet.
Photograph contained in State's Exhibit 9, Folder 3. This is photograph number 18, and it displays the garage door opener at 69 Wells Lane. This was identified as State Police Exhibit 11, 2 swabs of the exterior garage door opener open keypad from the center bay, and was subsequently designated as lab submission number 63. And I'm just reading from paragraph 3 of our stipulation.
Okay, hold on, because this is worthy of a pause moment. Look at, first of all, Jenny, happy 5-month anniversary to you. Happy 5-month anniversary to you. Second of all, let's take a moment and look at her. She says, my kids understood the assignment for my new profile pic. They didn't even ask any questions when I asked them to make it. Do y'all see this? Hold on. Look at this. It's a squirrel eating a cheeseburger as her profile picture. Jenny, not only is it our anniversary, and for that I appreciate you, but also you win the internet today, because the squirrel eating the cheeseburger profile picture is incredible in every way. So congrats to you. That's awesome.
And if you could read a little slower, please, at any beginning.
I'm sorry. I apologize, Your Honor. It was designated submission number 63.
That's hilarious.
And for your benefit, Ms. Madell, it's found in DNA
Hilarious.
supplemental reports number 2, 9, and 18.
Your kids deserve bigger allowances or whatever.
Was this given a sub-item
Whatever
as well?
kids get
Yes,
these
so
days.
63S1 was a designated swabs from, quote, garage door opener keypad.
And what were the results of the swabs from the garage door opener keypad?
The results are consistent with the DNA profile from item 63S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA from the swabbing of the electric toothbrush, Fotis Dulos, or Michelle Troconis are contributors to this profile. Assuming 2 contributors, the source of the DNA profile from the swabbing of the toothbrush, Fotis Dulos, and Michelle Troconis are eliminated as contributors to the DNA profile from item 63S1.
And you did additional analysis in DNA supplemental number 9 with known profiles, is that correct?
Correct.
And what were the results after you had a chance to look at the other known profiles?
Oh, I missed an anniversary. Wait, hold on. I gotta try to
The results are consistent with the DNA profile from 63S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 63S1 is at least 45,000 times more likely to occur if it originated from Lauren Almeida and 1 unknown individual than if it originated from 2 unknown individuals. The results do not support the hypothesis that C. Noel Dulos is a contributor to this profile. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to the DNA profile from 63S1. Petros Dulos, Konstantin Dulos, Christiane Dulos, Theodore Dulos, and Pavel Gumini are eliminated as contributors to the DNA profile from item 63S1.
And just to sort of short circuit this, going forward, with the court's permission, if the other children are eliminated, you could just say the other Dulos children, or
Okay.
Just to sort of streamline it.
Sure.
Happy anniversary. Well, PJW, happy anniversary.
I'm displaying for the court now State's Exhibit 9, folder number 2, picture 7, which shows the mud door handles, Your Honor. And with respect to the stipulation, it's agreed that this is State Police Exhibit 12. It was seized by Detective Riley and submitted to the State Forensic Laboratory as submission number 4. I'd like to talk to you about this DNA submission, if I could. Were swabbings taken of this particular object?
Yes.
And unlike some of the other objects where the swabs came in from the police department, Ms. Roy actually did these swabs. Is that correct?
Yes, that is correct.
Interior and
how many
exterior
swabs did she take in
doorknobs.
total?
On my supplemental DNA report, I have 2, 4-1S1 and 4-1S2.
All right. And I'd also direct you to DNA sub 2. I believe there's also 4-1S3. And
Correct, yes.
4-1S4. So there were 4 swabs total taken of these?
Yes.
Okay. Just beginning with the first swab, 4-1S1, what were the results for that swab? And this will be in DNA sub 1 and sub 9.
The results are consistent. The 4-1S1 was designated a reddish-brown ridge-like detail from front of knob. The results are consistent with the DNA profile from item 4-1S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 4-1S1. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 2 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 4-1S1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S1.
And when you did the additional analysis of the knowns in DNA sub 9, what were the results?
The results are consistent with the DNA profile from item, I'm on the wrong one. 4-1S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Konstantin Dulos could be a contributor to the DNA profile from item 4-1S1. The results do not support the hypothesis that Christine Dulos is a contributor. So assuming 2 contributors, Christine Dulos is eliminated. Results do not support the hypothesis that C. Noel Dulos is a contributor. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to 4-1S1. And then Petros Dulos, Theodore Dulos, Lauren Almeida, and Pavel Gumini are eliminated as contributors to the DNA profile from 4-1S1.
And just with respect to 4-1S2, which was found in DNA sub 1, no profile was obtained. Is that correct?
That is correct.
And with respect to 4-1S3, was that a swabbing of a doorknob and plate assembly with screws?
Yes, that's what it was designated.
And directing your attention now to DNA sub 2, what were the results?
flip through there.
The results are consistent with the DNA profile from item 4.1S3, being a mixture of 3 contributors, with at least one of them being male. Assuming 3 contributors, the DNA profile from item 4-1S3 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile of the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. Assuming 3 contributors, the DNA profile from item 4-1S3 is at least 330,000 times more likely to occur if it originated from Fotis Dulos and 2 unknown individuals than if it originated from 3 unknown individuals.
So
And Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S3.
Well, Attorney McGinnis, what the court is going to do is just ask a few questions so that it is clear what those numbers mean, but in a more narrative form. So, Ms. Maydell, when you indicated that certain, court is going to refer to it as likelihoods occur, when you use the numbers, would you explain in a narrative form what those numbers mean? So if someone is 45,000 times more likely to be X, what does that mean?
Well, it's a likelihood ratio that, given the evidence is more likely to occur if hypothesis 1 is true compared to hypothesis 2.
So would you rephrase it using those numbers?
So for the given evidence, it would be 100 times more likely, 100 billion times more likely, as an example, for hypothesis 1 to be true compared to what hypothesis 2 is.
So it's a comparison of the hypotheses.
Yes, only one of them can be true. So if that evidence is more likely to occur if the first hypothesis is true compared to the second hypothesis.
Thank you.
I believe you indicated for 1S3, it was 330,000 times more likely that Fotis Dulos was a contributor to the profile than if it were 3 unknown people. Is that correct?
330,000 times, yes.
And I'll just note, I think that's a misstatement of what the odds are. I think this is what they call the fallacy. It is odds of one thing occurring versus another, not that it's that person.
Well, what the court understood from Ms. Maydell's explanation is that we're comparing hypotheses. We're not talking about identification.
And just directing your attention to DNA supplemental report number 9, you again ran those additional knowns against the DNA profile from 4.1S3. And if you're ready, what were the results?
Sure. The results are consistent with the DNA profile from 4.1S3 being a mixture of 3 contributors, with at least one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 4.1S3. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 900,000 times more likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the electric toothbrush, and one unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 160,000 more times likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the toothbrush, and 1 unknown individual than if it originated from the source of the toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 30,000 times more likely to occur if it originated from C. Noel Dulos, the source of the DNA profile from the electric toothbrush, and 1 unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Konstantin Dulos, Christian Dulos, Theodore Dulos, and Pavel Gumeni could be contributors to the DNA profile from item 4.1S3. Lauren Almeida is eliminated as a contributor to the DNA profile from item 4.1S3.
I want to talk to you about 41S3 for a second. In DNA Supplemental 9, you assume that the profile from the toothbrush was a contributor. Can you just explain to the jury when you assume that a particular profile is a contributor to another profile?
I was thinking
what does that mean?
too.
So it's called conditioning. And when there's a scientific, reasonable expectation scientifically that a person's DNA could be on that item, it is sometimes better to assume that person so you can get a more accurate likelihood ratio to the other contributors that are contributing to that DNA profile. So after I did the first report where I compared the toothbrush and Fotis to the swabbing of the doorknob and plate and saw that they were both contributors, knowing that I'm going to now compare the children to that profile, because the children get half their DNA from their mother and half their DNA from their father, it's a given that those profiles are going to be there, because if they're contributing, then the children are going to have a likelihood ratio. So in order to give a more accurate likelihood ratio to if the children are contributing to that profile, we went and assumed the toothbrush because she's scientifically expected to be on that doorknob because that is her house.
The time is now 11:15. Ladies and gentlemen, we will take our morning recess. The court should indicate to you today that we will conclude today's session at 3 o'clock. So we ask that you retire to the deliberation room and please do not discuss the case.
Rick, thank you. Thank you for the super chat. I really enjoy your input to the trial. Thank you. I'm full of opinions. My favorite was the Murdoch trial. Thank you so much.
You'll resume at
Thank you.
11:30.
All right. This I'm most spirit and I'll stand in recess until 11:30.
Thank you for the super chat. We can skip forward a little bit. I know that this part is a little bit like wordy. There's a whole lot of words here. I mean, you know me, like I'm all for a chart. I wish they would just put it in a chart and, call it a day. But unfortunately, that's not the way they do it. So, it's all right. We're going to get through it. But it is a little bit wordy. It's just a little bit tedious to get through it. But think about it like this, y'all. Would you rather have this kind of tedious where it's just a bunch of words, or the kind of tedious where it's the defense attorney arguing with literally every single thing, all the things? So if you're going to have one or the other, I'd rather have this kind of tedious. So we'll see how it goes. Let's get through. Mermaid Mary B, the hearing today at 3 is perfect timing because they're ending court today at 3. So I don't think I have the Zoom info yet. I haven't looked anything up, but we are going to watch that as soon as they end today because it's actually perfect timing. There we go. For chart supplies, thank you.
Before the jury comes out, I would just note that we had a sidebar. There was a previous motion regarding motion in limine regarding the question about what did inconclusive mean. It was clarified by the state, but the state started getting into it knowing that there was a motion in limine again. The court did some clarification, and as far as I'm concerned, that was fine. But I would ask the state to realize that if I file a motion in limine, it's because there's an issue that should be resolved, so we don't have to do sidebar, and it doesn't require the court's intervention. Maybe he was inadvertent on Mr. McGinnis's part. I'm just raising it because we have a moment to do so.
Well, the record has to reflect that the court did act on the motion. The motion is denied, but that denial in this court's view is not to the prejudice of the defense because the court has the opportunity to ask questions, which would allow the jury not to be confused. For example,
I think they're confused.
This goes back to yesterday's discussion, the likelihood ratio. The likelihood ratio is simply a ratio of compared hypotheses. And so if the jury did not understand that previously, hopefully the jury understands that now. Are we ready to proceed?
I like this judge.
You can bring the jury
I
back
was
in.
digging the bow ties, but I actually like his little polka dot tie today. He's snazzy. I like him. I'm ready. Ready. My nurse made fun of me for that this morning. I wore this in today, and I told her that I had a shot of Jack with my cereal, and she said, that's okay. I had Captain Morgan and Captain Crunch for breakfast.
Okay, will counsel stipulate?
Yes, Judge. Yeah.
Okay, thank you. Attorney McGinnis.
Good morning again.
Good morning.
Ms. Maydell, I just wanted to ask you, when we were talking about hypotheses earlier, hypothesis 1 versus hypothesis 2, could you just explain to the jury in a little more detail what that means from your perspective? Does it mean it's one or the other? What exactly does that mean?
When we're creating these hypotheses, it's to describe how likely the evidence is to occur. Is it more likely to occur when hypothesis 1 is true compared to hypothesis 2?
So it's not an either or scenario.
No, it's if number 1 is true compared to what number 2 is.
Were there a number of results in this case in which you concluded that the contributor to the profile was a single female individual and that it was 100 billion more times more likely to be the profile on the toothbrush and everyone else was eliminated?
Yes, there is a bunch of those samples.
All right, I'd like to talk to you about those if I could. If we can call up Exhibit 15, or a photograph of State Police Exhibit 15, which is found in State Trial Exhibit 9, folder number 3, photograph 13. And just for the record, Your Honor, State Police Exhibit 15 was identified as 2 swabs of a blood-like stain seized from the scene, the handle under the sink cabinet door, kitchen island, and subsequently designated as submission 6. Were these results consistent with being a single female and the results being 100 billion times more likely to be the profile found on the toothbrush?
Yes.
If we can call up State Police Exhibit 35, which was identified as 2 swabs of a blood-like stain, G19, seized from the scene and submitted to the lab as submission 102. Were these the same results, being a single female 100 billion times more likely to result if it was the DNA profile obtained from the toothbrush as opposed to an unknown individual?
Yes, single female individual, yes.
So that's Jennifer again. Jennifer on the pantry, and then Jennifer's blood. All right, more blood.
This was identified as 2 swabs of a blood-like stain, G20, seized from the scene and subsequently submitted to the Division of Scientific Services as submission 103. Same results. And that's DNA sub 7 and sub 10.
Yep. Yes.
Jennifer's blood.
Staying with DNA sub 7 and 10 for your benefit, Ms. Maydell, if we can call up State Police Exhibit number 36, 37. And this was identified as 2 swabs of a blood-like stain, C2, KM positive, seized from the scene, subsequently submitted to the Division of Scientific Services and designated as submission 104. Was it the same result, Ms. Maydell?
Yes.
All right, another Jennifer's blood.
If we can call up State Police Exhibit 38, photograph of that. And this was identified as 2 swabs of a blood-like stain, B3, seized from the scene, North Bay, and submitted to the state lab as submission number 105. Were the results the same as single female?
Yes.
And just to be clear, a single female 100 billion times more likely to be the profile obtained from the toothbrush, is that correct?
Correct.
And everyone else was eliminated?
Correct.
So another of Jennifer's blood. These are not, this is
We can
not
call up a
surprising.
photograph of State Police Exhibit number 39. This was identified as 2 swabs of a blood-like stain, B11, seized from the scene, KM positive, North Bay, subsequently submitted to the Division of Scientific Services as submission 106. What were the results of this?
The same as the previous result. Single female, assuming 1 individual, the DNA profile from item 106S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from a... Sorry. assuming one individual, the DNA profile from item 101S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from a swabbing of the electric toothbrush than if it originated from an unknown individual.
We can call up State Police Exhibit number 41. Photograph of that.
Well, Your Honor, I note that the witness skipped the last sentence of her report, of her finding on that particular item. I just ask that she read the remaining sentence.
Well, Attorney McGinnis, is there another sentence that was not read from the conclusion?
I'm unclear, Judge. I'm assuming he's referring to everyone being eliminated? Everyone else being
The court
eliminated?
does not know because the court does not have the exhibit.
So these results that we're going through now are consistent with the profile of the that you obtained from the toothbrush being 100 billion times more likely to be the source of these profiles. Is that correct?
Versus an unknown profile.
Right. And everyone else has been eliminated. These results are all the same, correct?
Correct, so far.
These are all things that they've already gone over.
If we can call up a photograph of State Police Exhibit 41. This was identified as 2 swabs of a blood-like stain, A18, KM positive, seized from the scene, and subsequently submitted to the Division of Scientific Services and designated as item 108. Were these results the same as your previous answer?
Yes.
So another of Jennifer's blood.
If we could call up State Police Exhibit number 45. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 109. Is the results of this test the same?
Yes.
Jennifer's blood.
If we could call up State Police number 48.
And that's one of the ones where it looks like they had tried to clean it.
This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 112. Were the results here the same?
Yes.
If we could call up State Police Exhibit 59.
Oh, wrapper's back.
This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left side of the hood, subsequently submitted to the Division of Scientific Services and designated as submission 118. Were the results of this the same?
Yes.
If we could call up Exhibit 60. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left front corner of bumper, subsequently submitted to the Division of Scientific Services as submission 119. Were the results here the same?
Yes.
If we could call up State Police photograph 61. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, exterior side of left front door, subsequently submitted to the Division of Scientific Services and designated as submission 8. Were the results of the analysis here the same? And that's in DNA Sup 1 and Sup 9.
Yes.
If we can call up State Police Exhibit 62. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the garage 2014 Land Rover, exterior side left rear door, subsequently submitted to the Division of Scientific Services and designated as submission 121. Were the results of this test the same?
Yes.
This is all Jennifer's blood.
We can call up State Police Exhibit 63. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, 2014 Land Rover, left rear fender, subsequently submitted to the Division of Scientific Services and designated as submission 120. Were the results of this test the same?
Yes.
At least now the way they're going through it like this, it's making it a little bit
We can
easier
call
for
up
the
State Police
jury
Exhibit 64.
to
Oh, I'm sorry, I don't think we have a photograph of 64. State Police Exhibit 64 was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, east wall of garage, north of door 2 mudroom. Were the results of that test the same?
Sorry, what item number for the lab?
Oh, I apologize. Submission 100 and 22.
Yes.
We can call up State Police Exhibit 65. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can western, subsequently submitted to Division of Scientific Services and designated as submission 9. Were the results of this test the same? And that's in DNA sub 1 and sub 9.
Yes.
If we can call up State Police Exhibit 66. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can eastern, and subsequently submitted to the Division of Scientific Services and designated as submission 123. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 78.
Jennifer, blood again. So Nancy says, not sure what all this has to do with Michelle's part in the murder. See, that's the thing.
This
and
was
I kinda went
identified
over
as
this
2
yesterday.
swabs of a blood-like stain, KM positive, seized from the scene, kitchen island countertop edge
They
north
have
of sink.
to
Subsequently
first
submitted to the
prove
Division of
that
Scientific Services and
Fotis
designated
did
as
it,
submission 10.
and
Were the
then
results of
prove
this test the
Michelle's
same?
part.
Yes.
So it's like it's 2 trials in one, but
If we
we
can
haven't
call
even
up
gotten to
Exhibit-
Michelle's
State Police Exhibit
involvement
320.
yet. They have to first prove that Jennifer was killed, then that Fotis did it, then that Michelle had a part
This
in
was
it.
identified as suspected biological matter E, seized from the scene, garage, 2014 Land Rover, lower edge, left front door, subsequently submitted to the Division of Scientific Services and designated as submission 132. Were the results of this test the same?
Yes.
Yay, get the memberships. Hi, Linda.
If we can return to State Police Exhibit number 13.
This is what they're going over now. Is whose blood is whose. So obviously, like the all the spots they're going through right now in the garage.
This was
have all been
identified as one
Jennifer's
used
blood.
paper towel roll with blood-like stains, KM positive, seized from the scene, kitchen island countertop, east of sink, and subsequently submitted as submission 101. Were the results of this the same? This is from DNA sub 7 and 10.
Allie B from Tennessee, good luck on your interview.
You said number 110?
101.
101. Correct, yes.
Okay.
So again, Jennifer's blood.
If we could call up State Police Exhibit 14.
Yeah, they'll get there eventually.
This was
It's just that
identified
this
as 2 swabs of a blood-like stain, KM positive, seized from the scene, kitchen sink, faucet spout, and subsequently submitted to the Division of Scientific Services and designated as submission 5. Can you let us know what the results were of this? This is from DNA sub 1 and 9.
All right, so here's the faucet.
The results are consistent with the DNA profile from item 5S1, being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, the DNA profile from item 5S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, the DNA profile from item 5S1 is at least 4.3 billion times more likely to occur if it originated from Fotis Dulos and 1 unknown individual than if it originated from 2 unknown individuals.
Bam!
Michelle Troconis is eliminated as a contributor to the DNA profile from item 5S1.
Fotis'
And directing your
DNA.
attention now to DNA supplemental
On the
report number
faucet.
9. Did you reanalyze this profile and assume that the profile from the toothbrush was a contributor?
Yes, again, knowing from this first report that it was a 2-person mixture and it looked like a mixture of the parents of the children, I went and created a new
Only facts.
hypothesis to make that second contributor more discriminating. So I ran the children all against that first deconvolution of the 2-person mixture in order to determine who had the highest likelihood ratio between the toothbrush and the 5 children. So then I could then assume one of them and make a comparison to that second person. So after I did that, the toothbrush had the highest likelihood ratio as being a contributor. And when you assume somebody on a profile, it increases the likelihood ratios of true contributors, but it will decrease the likelihood ratio of non-contributors. So it is a scientifically sound conclusion to do. So after I did that, then I made my conclusions in Supplemental 9.
And what were the conclusions?
The results are consistent with the DNA profile from item 5S1 being a mixture of two contributors with one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 5S1. Assuming two contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from 5S1 is at least 100 billion times more likely to occur if it originated from Fotis Dulos and the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual. Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, Theodore Dulos, Laura Almeida, and Pablo Gumini are eliminated as contributors to the DNA profile from 5S1.
So all the other known profiles that you had, including the defendant, were eliminated. Is that correct?
Yes, after I assume the toothbrush as a contributor to the profile, the children are eliminated and cannot be the second contributor.
So all that to
we
say,
can call
Fotis
up,
was up in there.
State Police Exhibit 40.
Fotis was up in there.
And this was identified as two swabs of a blood-like stain, A15, KM positive, seized from the scene, North Bay, subsequently submitted to the Division of Scientific Services as submission 107. And this is found in DNA Supplemental Report 7 and 10 for your benefit, Ms. Maydell. What were the results of the analysis here?
S1, you said?
Yes.
The results are consistent with the DNA profile from item 107S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 107S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Due to the limited data detected from item 107S1, the comparison to Fotis Dulos and Michelle Troconis are inconclusive.
What does that mean when you say due to limited data?
So this is was designated a two-person mixture. So the major profile being so I probably had a major profile with a minor profile. So looking at the toothbrushes being 100 billion times more likely, that was the major profile in the within that two-person. And there was only one, probably, I don't want to speak without seeing the actual data, one peak that wasn't attributed from that DNA profile from the toothbrush. And Fotis Dulos and Michelle Troconis have that peak, so I can't say conclusively if they're a contributor or not, but I can't eliminate them either.
If we can call up State Police Exhibit 42.
Yeah, it's all, because it's all circumstantial and there's no body, they have to go through all
This was
of
identified
every
as a
single
fragment of
piece
a paper towel with a
evidence.
blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item 65, or submission 65, I should say. And for your benefit, Ms. Maydell, this is found in DNA Sub-Reports 3 and 9.
They tested multiple
Sorry, can you repeat the
toothbrushes.
number?
65.
Jennifer's,
The results are
Was
consistent
one of them.
with the DNA profile from item 65S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 65S1 is at least 2.5 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from item 65S1.
And in fact, all known other profiles were eliminated. Is that correct?
Let me just double check. What was the other report?
Sub 9.
And I'm going to object to mischaracterization. If I may just have a moment.
So there was no autopsy because they never found the body.
Oh, I apologize.
So they
Sustained.
didn't, there was never
I apologize,
actually
Your
an
Honor.
autopsy done.
If you could just read the results when you compared it to the other knowns.
Sure. The results are consistent with the DNA profile from item 65S1 being a mixture of two contributors. Assuming two contributors, given the low likelihood ratios calculated, The results are inconclusive whether Theodore Dulos could be a contributor to the DNA profile from 65S1. The other children, Lauren Almeida, Pavel Gumini, are all eliminated as contributors to 65S1.
If we can call up State Police Exhibit 43. And this was identified as a fragment of a paper towel with a blood-like stain and submitted to the Division of Scientific Services and designated as submission 66. And this can be found in DNA reports 3 and 9.
The results are consistent with the DNA profile from item 66S1 being a mixture of two contributors.
Oh,
Assuming
Fotis
two
Dulos,
contributors,
I see.
the DNA profile from item
That was
66S1
later.
is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from 66S1.
So that one had Jennifer
And was there additional swabbing of the paper towel that was designated as 66S2?
Fotis and Michelle were eliminated from that one.
I'm sorry. S.
Yeah, there was a 66S2 and 66S3.
Okay. So can you just indicate to the results of 66S2, which was identified as swabbing of paper towel side A?
There was no DNA profile detected.
And similarly, the results for 66S3, the swabbing of the paper towel side B?
No DNA profile detected.
If we can call up State Police Exhibit 44.
I didn't do the results for 66S1 against the children.
Oh, I apologize. If I can just have a moment. Yes, if you could tell us the results of 66S1.
So the results are consistent with the DNA profile from 66S1 being a mixture of two contributors. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 66S1. Lauren Almeida and Pavel Gumini are eliminated as contributors to the profile from 66S1.
If we could bring up State Police Exhibit 44. This was identified as a fragment of a paper towel with a blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item submission number 67. And there were actually two separate analysis of this particular item. There was a fragment of the paper towel, and then there was a swabbing of the paper towel. Is that correct?
Yes, 67S1 and 67S2.
Okay, so let's start with 67S1, which was actually a fragment of the paper towel. What were the results for that?
The results are consistent with the DNA profile from item 67S1 originating from a single female individual. Assuming one individual, the DNA profile from 67S1 is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual.
So again,
Fotis Dulos
Jennifer.
and Michelle Troconis are eliminated as the source of 67S1.
And directing your attention now to supplemental report number 9, the Dulos children, as well as Lauren Almeida and Pavel Gumini, were also eliminated. Is that correct?
Correct.
And what were the results of 67S2, which was a swabbing of this paper towel fragment?
No DNA profile was detected.
If we can call up State Police. Actually, I don't believe we have a photograph of 46, but State Police 46 is identified as two swabs of a blood-like stain KM positive seized from the scene North Bay, subsequently submitted to the Division of Scientific Services and designated as submission 110. And for your benefit, Ms. Maydell, it's found in DNA supplemental reports number 7 and 10. Could you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 110S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the DNA profile from item 110S1.
And then when you had an opportunity to test that profile against additional knowns in DNA supplemental report 10, what was your conclusion?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether Fotis Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be the source of the DNA profile from item 110S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 110S1.
If we can call up State Police 47. This was identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 111. And Ms. Maydell, for your benefit, these results are found in supplemental reports 7 and 10.
The results are consistent with the DNA profile from item 111S1, originating from a single individual. The source of the DNA profile from
Okay,
the swabbing
so
of the electric toothbrush is eliminated
basically-
as the source of the DNA profile from item 111S1.
So
Fotis
far,
Dulos and Michelle Troconis are also eliminated as the source of the DNA profile from item 111S1.
all we've gotten is that
And then we
all
did
of the
additional
blood
comparisons to
stains
other knowns
in
DNA
the
supplemental
garage
reports.
belong to Jennifer, and Fotis's DNA was on the
Assuming one
interior
individual, given the low
doorknob
likelihood ratios
in the
calculated,
mudroom
the results are inconclusive to
and
whether
the kitchen
Fotis Dulos,
faucet.
Christiane Dulos, or Theodore Dulos could be a source of the DNA profile from item 111S1.
None of
Constantine
Michelle's
Dulos, C. Noel Dulos, Lauren
and
Almeida,
none of
and
Powell.
Paolo Gumini are eliminated as the source of the DNA profile from item 111S1.
If we can call up
That's
State
what-
Police number 49.
all of this has gotten us to so far. Here, you know what? We're speed trialing.
Only submitted to the Division of Science.
No DNA profile was detected.
No DNA profile. That was a radish. Got it.
From the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 114. We're here.
The results are consistent with the DNA profile from item 114S1 being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 114S1. Fotis Dulos is eliminated as a contributor to the DNA profile from item 114S1. The results do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 2 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from item 114S1.
And then when you did additional comparisons of the knowns in DNA supplemental report number 10, were all the other known profiles eliminated, the Dulos children, Lauren Almeida and Pavel Gumimi?
Correct, yes.
Yeah. He has never been inside that house. And
If we could
you
call
know,
up State Police number 51.
they made a big deal about, remember when he was there on Wednesday? They made a big deal about making sure, you
State
know,
Police 51 is
like
identified as
he
2
was
swabs
never
of a
allowed in the
blood-like
house.
stain, KM
The doors
positive,
were
seized from the
locked.
scene, South Bay, subsequently submitted to the Division
He
of
was
Scientific
only
Services
allowed on
and
that back
designated as submission
patio
number
and
115.
never entered the home at all.
Ms. Maydell, this is also in reports 7 and 10. Can you
And
indicate
there
to
was
the jury what the results
a
were?
chaperone
The results are consistent
because he had to
with
have
DNA
the
profile
chaperone,
from
remember,
item
for
115S1 being a mixture of 3 contributors.
he had to have the chaperone for his visits with his kids, and the chaperone had even said like he never stepped foot in the house.
From the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 115S1. The results do not support the hypothesis that Fotis Dulos or Michelle Troconis are contributors to this profile. Assuming 3 contributors,
And also, you
Fotis
know,
Dulos and Michelle Troconis are
you
eliminated
notice
as
that
contributors
part
to the
of
DNA
what they're
profile from
doing, I know that this gets tedious and kind of boring, so we're gonna get through it though.
And do you supplemental report number 10 when you had
but
the benefit of doing additional
they're-
comparison?
Michelle's DNA is nowhere inside of that house.
The results are consistent
It's
with the
nowhere
DNA
inside of
from 115S1
Jennifer's
being a mixture of
car,
3 contributors with at least one of them
but
being
that's
male.
not part
Fotis
of
Dulos,
the
Constantine
conspiracy.
Dulos, Christiane Dulos,
Nobody-
Pavel Gumeni are eliminated as contributors.
nobody
to the
in the,
profile from item
like,
115S1.
The conspiracy doesn't have anything to do with her
Assuming
being
3
present when all of this
contributors,
happened.
given the low likelihood
The
ratios calculated, the
whole
results
thing
are
is that it was
inconclusive as to
Fotis who
whether C.
actually
Noel
carried
Dulos
it out,
could be a
but
contributor
it
to the
was,
DNA profile from 115S1.
they say that they have
And the results
evidence
do not
of
support the
her being
hypothesis
involved
that
in the
either
conspiracy
Theodore
for it.
Dulos or Laura Almeida are contributors to the
So they're going through and they're showing that, like, okay, yeah, her DNA is not on there anywhere in the house, whatever. The blood is all Jennifer's, and it is like, these aren't just radish stains. This is actual, you know, it has DNA in it. So this is actual blood belonging to to Jennifer, and see how they're all like, you know, like dots and spatter. That's consistent with like blunt force trauma, being, you know, hit and blood, you know, splattering out. So that is, even though it's tedious to go through all these and show it, it's important to show, look how many like little dots, even, and this is after the cleanup efforts. This is after they made the attempt, or Fotis made the attempt to clean everything up with his, you know, 10 rolls of paper towels. So there's still all these dots of all this blood. Michelle's DNA doesn't come in until they start talking about the DNA that was tested on the tour of trash cans on Albany Avenue. So when we get to that and they go through the DNA on that stuff, it'll be another one of those things where it's like this, it's giving us a whole lot of words, but we're basically going to have to, you know, yes, this is Jennifer's. It's going to be a whole lot of, yes, this is Jennifer's blood. It's going to be a whole lot of that. And then there's going to be those few things of, yes, this is Fotis, you know, this is his DNA, this is his fingerprint, whatever, this is Michelle's DNA. So when we get to that part, it's going to be a whole lot more words, but it's going to be getting through all of that word, you know, all those words coming at you is going to be some of the most damning testimony that there is. So it's tedious to get through it, but it's really important stuff. Another thing, they're going through, you notice that they're comparing it to the kids and to the nanny and all of that stuff too, but they're also comparing it to Powell. And one of the things that's important about that too is that with Fotis taking Powell's truck, you know, he was the one that owned the Tacoma, and him taking his truck to do all this, whatever. Powell actually believed at one point that, and he might still, we'll hear from him, you know, he's going to testify, but he believed that Fotis was actually trying to frame him for it, because he did have him not only working in New Canaan that day, but he had him working in New Canaan, but he drove his truck. And also, remember they were showing the pictures of Fotis yesterday, and they were asking about him having a shaved head? His shaved head was, like, in all of the other pictures that we see him in, he didn't really have a shaved head. But then all of a sudden, right around the time that this happened, Fotis shaved his head. If you remember the picture from the website that they showed of Powell yesterday, he had like a shaved head. So if he were to have been seen, now you have him looking consistent with Powell's description in Powell's truck in the city that Powell was scheduled to work in that day. So it's kind of like, I don't think that he was necessarily trying to frame him, but I think that he was trying to set it up so that if they were to look at somebody, Powell would have been the one to go down instead of him.
Inconclusive as to whether Fotis Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 68S1. Lauren Almeida and Pavel Gumini are eliminated as contributors to the DNA profile from item 68S1.
And if we can call up State Police 79.
Cast off blood spatter. And there's a lot.
This was identified as 2 swabs of a blood-like stain KN positive seized from the scene, the kitchen sink faucet handle, and subsequently submitted to the Division of Scientific Services and designated as submission 11. And this can be found in DNA supplemental report number 1 and 9, Ms. Maydell.
I think the jurors will be confused unless it's all
The
going to
results are
rely on
consistent
closing
with the DNA
arguments.
profile from item 11S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 11S1. Fotis Dulos and Michelle Troconis are eliminated as a source of the DNA profile from item 11S1.
And then
So
directing your
this
attention to DNA supplemental report number 9.
From this part. Remember, his DNA
You had
was
the benefit
on
of doing additional comparisons with knowns.
Yes.
the
Results are consistent with the profile
Front part
from
of the
11S1 originating from a
faucet.
single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive to whether Fotis Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, and Theodore Dulos could be the source of the DNA profile from 11S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 11S1.
If we can call up State Police Exhibit 319.
They did talk about the pantry. The pantry was one of the first things that they did, and that had Jennifer's DNA But
State Police 319 was identified as suspected biological
that
matter.
was the only confirmed one.
D, seized from the scene, 2014 Land Rover, left front fender, and subsequently submitted to the Division of Scientific Services and designated as submission 131. Then directing your attention to DNA supplemental reports 7 and 10. Could you indicate to the jury what the results were?
Sorry, what was the number again?
131.
31. The results are consistent with the DNA profile from item 131S1 originating from a single female individual. Assuming one individual, the DNA profile from item 131S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of an electric toothbrush than if it originated from an unknown individual.
And were Fotis Dulos and the defendant eliminated?
Yes.
And in DNA supplemental report number 10, were the Dulos children, Lauren Almeida and Pavel Gumi, eliminated as well?
Yes, correct.
Yeah, I don't think he counted on them having that high-tech center where they
If we
have
could
all
call
of
up
the
just State Police Exhibit 12
cameras
for one
and
moment.
all of that. Those are high-definition cameras,
I think
too.
we've talked about the fact that there were 4 separate swabbings of this, and I think we got through 1S1 through 1S3. I wanted to just talk to you about the results of 1S4. And that's identified as the swabbing of a doorknob and plate assembly without screws.
1S4?
That's correct, ma'am.
Okay.
And this is found in DNA subs 2 and 9 for your benefit, Ms. Maydell. Could you just indicate to the jury what the results were?
The results are consistent with the DNA profile from item 4-1S4 being a mixture of 4 contributors, with at least one of them being male. Assuming 4 contributors, the DNA profile from item 4-1S4 is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 3 unknown individuals than if it originated from 4 unknown individuals. The results do not support a hypothesis that Fotis Dulos is a contributor to this profile. Assuming 4 contributors, Fotis Dulos is eliminated as a contributor to the profile from item 4-1S4. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S4.
And when you did the additional comparisons?
Assuming 4 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 4-1S4. Assuming 4 contributors, the DNA profile from item 4-1S4 is at least 130,000 times more likely to occur if it originated from Christiane Dulos and 3 unknown individuals than if it originated from 4 unknown individuals. Lauren Almeida and Pavel Gumini are eliminated as contributors to the DNA profile from item 4-1S4.
I'm now going to shift around. I'm going to be publishing things from State's Exhibit 28, which is the stipulation regarding evidence seized from Jennifer Dulos' Chevy Suburban.
Thank you.
Ms. Maydell, you recall approximately 45 minutes to an hour ago, we talked about results in which there was a single female contributor, and it was 100 billion times more likely to have occurred if it was the profile from that you obtained from the toothbrush as opposed to an unknown individual. Do you recall that testimony?
Yes.
All right. And in those instances, everyone else, all the other knowns were eliminated. Is that correct?
That is correct, yes.
All right. I want to just direct your attention now, if we can call up State Police Exhibit 105. This is identified as 2 swabs of a blood-like stain KM positive taken from the rear bumper step of a 2017 Chevrolet Suburban and subsequently submitted to the Division of Scientific Services and designated as item 124. Were those the same results that we were just discussing? This can be found in DNA supplemental report numbers 7 and 10.
Yes, that is correct.
And if we can call 106. Same results. I'm sorry. Let me publish. This is State Police Exhibit 106. identified as 2 swabs of a blood-like stain taken from the exterior side of the right rear door and submitted to the Division of Scientific Services and designated as submission number 15. Were these the same results, Ms. Maydell?
Which report is that?
Oh, DNA supplemental report number 1 and 9.
S1, yes.
And if we can call up State Police 107. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the running board under the right front door and subsequently submitted to the Division of Scientific Services and designated as submission.
So many words.
The steps, if I could just have one moment, Your Honor.
No. See, this 100 billion times more likely of this and this and this. This is all the, like, the stuff that defense was trying to keep out. All the comparisons that that defense did not want them giving.
If I could just have one moment, Attorney Schoenhorn. I think I have a scrivener's error. If I could just have one moment with Attorney Schoenhorn.
No. Oh, we have 5 minute or 5 second skip. Duh.
7 is identified as 2 swabs of a blood-like stain, KN positive, taken from the running board under the right front door, subsequently submitted to the Division of Scientific Services and designated as submission 125. With respect to this, are these the same results, meaning 100 billion times more likely to originate from the profile obtained from the electric toothbrush than an unknown profile, and all other known individuals to you were eliminated?
Yes.
If we could call up State Police Exhibit 120. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the left side of the cargo area and subsequently submitted to the Division of Scientific Services and designated as submission number 70. Same results.
Yes.
It's a different report.
DNA sub 3 and 9.
The DNA on all the blood in the garage and everything was Jennifer's, and Fotis's DNA is on one of the swabs on the faucet inside the kitchen.
Correct.
And the kitchen faucet, and also
We
the
could call up
mudroom
State Police number 316.
doorknob. Those have been the positive ones so far.
This was identified as 2 swabs from Area A, subsequently submitted to the Division of Scientific Services and designated as submission 100. I'm sorry? Oh, we don't have 316? Okay.
Can I have a moment with counsel for a brief moment?
No.
Retire to the deliberation.
Paperwork?
Oops.
Yes.
Thank you.
Ladies and gentlemen, please retire to the deliberation room and please do not discuss the case.
Where's she going? Stretching? Yoga? Yoga time? Or did she drop something? Definitely yoga. Maybe she just dropped something. All right, let's skip forward. Moving right along,
Well,
fellas.
the court understands that the jury room is being provided air conditioning. So the court is
them
just
awake.
going to indicate to the jury that we will address that in about 15 minutes. We can bring the jury in.
Bring the jury.
Cole, will counsel stipulate to the presence of all of the jurors?
Yes, Judge.
Yes.
Thank you. You may proceed, counsel.
Ms. Maydell, where we left off, we were discussing State Police Exhibit 316, which was seized from the Chevy Suburban and identified as 2 swabs from Area A and subsequently submitted to the Division of Scientific Services and designated as submission 128. For your benefit, this is DNA reports 7 and 10. What were the results?
number 128 is the same as what we were previously talking about. Single female individual, assuming one individual, the DNA profile from item 128S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And everyone else is eliminated.
And if we can bring up State Police Exhibit 317. No, okay, I apologize. Submission, or State Police Exhibit 317 was identified as 2 swabs from Area B from the Chevy Suburban and subsequently submitted to the Division of Scientific Services and designated as submission number 129. Same results?
Yes.
We're going to go to 1.5.
State Police Exhibit 318, which was identified as 2 swabs from Area C of the Chevy Suburban and designated as submission 130. Same results?
Yes.
Some more of Jennifer's blood. I wonder if she does. I wonder what she knows. They said that they have a lot of evidence against her that we haven't heard yet. So, you know, a lot of what's going to be interesting is
identified as 2 swabs taken of the top half of the steering wheel
conversations
and subsequently submitted to the Division of Scientific Services as submission number 12. And for your benefit, Ms. Maydell, this is in reports 1 and 9. What were the results?
The results are consistent with the DNA profile from item 12S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 12S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive to whether Fotis Dulos could be a contributor to the DNA profile from item 12S1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 12S1.
And directing your attention now to DNA Supplemental Report number 9. It's my understanding that with the exception of Theodore, the Dulos children, Lauren Almeida, and Pavel Guimi were eliminated.
That is correct. The low likelihood ratio is calculated. The results are inconclusive whether Theodore Dulos could be a contributor to the profile of 12S1.
State Police Exhibit 100.
Could I just have a moment, counsel?
No.
Taken from the bottom half of the steering wheel and subsequently submitted to the Division of Scientific Services as submission number 13. And this is in DNA reports 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 13S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 13S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from item 13S1.
And DNA Supplemental Report number 9. My understanding is that the Dulos children and Pavel Guimi were eliminated and the results were inconclusive as to Lauren Almeida. Is that correct?
That is correct.
State Police Exhibit 101, which was identified as 2 swabs taken from the gear shift and subsequently submitted to the Division of Scientific Services as submission number 14. And this is found in reports 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 14S1 originating from a single female individual. Assuming 1 individual, the DNA profile from item 14S1 is at least 780,000 more times likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Dulos and Michelle Troconis are eliminated as a source of the DNA profile from 14S1.
And in DNA Supplemental Report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Guimi, were eliminated. Is that correct?
That is correct.
We can call up State Police Exhibit 108. This was identified as 2 swabs of a blood-like smudge, KM positive, taken from the exterior side of the right front door and subsequently submitted to the Division of Scientific Services and designated as submission 126. And Ms. Maydell, for your benefit, this can be found in DNA's reports 7 and 10. Could you just indicate what the results were?
Can you repeat the number again? 126?
6.
The results are consistent with the DNA profile from item 126 being S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 126S1 is at least 11 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from number 126S1.
And in DNA Supplemental Report number 10, I believe you concluded that given the low likelihood ratios, the results were inconclusive as to the Dulos children. However, Lauren Almeida and Pavel Guimi were eliminated. Is that correct?
Yes, that is correct.
State Police Exhibit number 113. This was identified as 2 swabs of a latent smudge from the exterior side of the tailgate and subsequently submitted to the Division of Scientific Services and designated as submission number 16. And this is in reports 1 and 9 for your benefit, Ms. Miguel.
The results are consistent with the DNA profile from item 16S1 originating from a single female individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 16S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the profile from item 16S1.
And in DNA supplemental report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Guimi, were eliminated. Is that correct?
So
That is correct, yes.
a lot of what they're going over now, remember the Suburban that was found, her Suburban that was found, they believe that Fotis drove to
State Police Exhibit number
Waveney
119.
Park.
This was identified as 2 swabs
Samples
taken
from
from
that.
the garage door opener on the driver's side visor and subsequently submitted to the Division of Scientific Services and designated as submission number 69. And it's found in reports 3 and 9, Ms. Madel.
The results are consistent with the DNA profile from item 69S1 being a mixture of 3 contributors, with at least one of them being male. Assuming 3 contributors, the DNA profile from item 69S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 3 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 69S1. And the results also do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 3 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from 69S1.
And in DNA supplemental report number 9, you concluded that Lauren Almeida, Pavel Guimi were eliminated. You also concluded that all of the children, with the exception of Constantine Dulos, was eliminated. And with respect to Constantine Dulos, you concluded that assuming 3 contributors, it was 210,000 times more likely to occur if Constantine Dulos was a contributor with 2 unknowns as opposed to 3 unknowns. Is that correct?
Christiane Dulos.
Christiane Dulos, excuse me.
Yes. Constantine's eliminated. Christiane is the 210,000 more times likely.
If we can pull up states 121. This is identified as 2 swabs of a blood-like stain KM positive taken from the cargo area floor and subsequently designated as submission number 17. And this is in reports 1 and 9 for your benefit, Ms. Madel. What were the results of this?
The results are consistent with the DNA profile from item 17S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 17S1 is at least 31,000 times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from 17S1.
Attorney McGinnis, we are going to take our lunch and recess at this time.
Judge, I'm sorry, may I just finish up with this one exhibit? Just one more question.
Well, remember, we are only going to be here an hour at 2 o'clock. So you may finish.
Thank you. And just continuing on to supplemental report number 9, what was your conclusion?
Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be a contributor to the DNA profile from 17S1. And Lauren Almeida and Pavel Guimi are eliminated as contributors to 17S1.
Thank you, Judge.
Ladies and gentlemen, we will attempt to address the frigid conditions in your deliberation room. And we'll resume at 2 o'clock. We will only have an hour this afternoon before we adjourn. So please do not discuss the case and have a good lunch.
She's definitely hiding from the cameras. Like, she has her hair pulled. Like, she knows where the camera is. And
This for announcements and recess.
you can tell she kind of tries to hide her face. See, even then she pulled her hair over her face. She's using it like a comfort blanket. Trying to hide it. All right, so this is, like I said, I get it. It's wordy. It's very wordy. But let me get to the afternoon. Let's get to the afternoon. Oh, they haven't started afternoon yet. Oh. We're caught up. Are we? Oh, they're coming back right now.
The next several results that I'm going to be discussing with you are found in DNA Supplemental Report 11.
Hold on. Hold, please. Hold, please. Hold, please. Let's see here. Let's see here. They have it going on this one, but not on my Fox one. Okay, are we ready? Are we ready?
And
Not you. Calm down. Calm down. Calm down,
I'm
not
just going to
you.
read from the
I say ready, and
stipulation
she thinks
here,
it's time to go for a ride.
State's Exhibit number 28. State Police Exhibit 370 identified as 4 swabs from an unstained area of the steering wheel and subsequently submitted to the Division of Scientific Services and designated as submission 134. Ms. Maydell, what were the results of that submission?
The results are consistent with the DNA profile from item 134S1 being a mixture of...
So the only thing about now being caught up is that now we have to listen to the DNA stuff in real time. That's the only bad part, but that's okay. We'll just pause it for a second, and everybody, it's yoga time. This is where Judge Newman would tell us to pause and stretch. Here, stretch, Woosie. Stretch. Say, stretch your little arms. Lean over to the side, and lean over to the other side. I love you. She's like, sometimes she's like my best friend, and sometimes I think she feels like a hostage. But either way, all right, let's see. Let's talk for a minute while we wake ourselves up from DNA talk for that long. It is only real time for 1 hour. They only have 1 hour left. So they only have 1 hour left. And then they're done for the day, and then we'll watch the Karen Reed hearing. It's gonna be a snooze. Yeah. I wonder, do you think that the jury heard that and registered that Fotis was positive for being on the faucet and on the interior mudroom door? Or do you think that was so many words that it was too hard to really focus on? Do you think that they got it? I'm curious. Like I said, it's kind of hard on this one to separate what we know from what they know. Okay, y'all are thinking they did. I hope so. A diagram would have been much easier on the jury. I mean, look, y'all know I love me a diagram. I love me a chart. I love me some graphics. So, of course, I'm going to, always be very pro chart and pro graphics. Yeah, it would have been a lot easier, though. Why only 1 more hour? They said that they are releasing early today. They're releasing at 3 today for whatever reason. I think it's because I had told them that I wanted to cover the Karen Reed hearing also. So they were like, you know what? Brandi's got stuff to do. So we'll peace out at 3 today so that she can cover the hearing. Maybe they will use the diagram during closing. I'm thinking possibly, if they don't have the diagram, then they'll at least have to go through the whole thing about, maybe even if they say, like, I didn't count how many of those there were, but however many of those, like blood spatter samples that they tested for DNA and they came back positive for Jennifer's DNA, even if they say, even after Fotis, attempted to allegedly clean the scene of the crime, there were still, 40 something, blood spatter pieces that came back positive for Jennifer's blood, which is of course that's the sign of a crime scene, plus all the blood that they're going to see on the items that were recovered from the trash bags. And if they hit on that and then make sure to point out that there's never a time when Fotis should have been inside that house, but yet his DNA was not only on the faucet, but also on the interior mudroom door, which both of those areas, that puts him obviously inside the house when he never should have been in there. And, along with all of the other evidence. The thing is, with all of this evidence, one piece by itself would have nothing to do with anything. But when you put all of it together, that's the way circumstantial cases work. So they have to get all of this, all of these little pieces in, because all of it works together to paint the entire picture. So the closing arguments are going to be so crucial in this case. So crucial. So, yes. And yes, Betsy Jean, the jury can take notes. So the jury can take, and the truck. Oh yes. And the truck seats. So the truck seats, and that's going to be one of the reasons that Powell's testimony is going to be, I'm ready for that. But also, they have said that Kent, the friend / former attorney who was also charged, they have said that, or he has said, apparently that, it has been reported that he is possibly going to testify. If he testifies to get himself out of trouble, because remember, his old buddy Fotis, he gone. So now, it's just him and Michelle that are in trouble. So he doesn't owe any loyalty to Michelle. He didn't meet her until within a month of all of this happening, right? So if he testifies to get himself a deal, that is going to be the mic drop, bombs exploding, holy crap testimony. So, because then we're going to get all of the inside information, because he's the other one who's charged with all of this. So I would love for him to testify, because there will be things that we would never have known without him telling us. But, we'll see. I know that police have said that they have extensive evidence against him. It said against the defendants. This is when Fotis was still alive too. So against the three. So against Michelle, Fotis, and Kent. They said that they have extensive evidence showing that there was a lot of planning that went into this, which is why they had the conspiracy charges. Obviously, we haven't seen it yet. They haven't released it to the public. So there's going to be a lot of, this is going to be kind of like the kennel video in the Murdoch trial where, we're all sitting there going, oh, that was his voice. That was his voice. That's kind of what I'm expecting for this, because they said they have all this evidence that we haven't seen. It's not in any of the court documents. I went through 400 and however many pages of one document, and then 2 of them were 35 pages each. And, I went through all of that, and there's none of that in there. So this is going to be the really explosive testimony if he does. But also Powell was, Powell believes that he was trying to frame him, and hearing him, that's why he saved the seat. That's why he, told police, hey, that's not the seats that were in that truck that day. He told me to get rid of them and never bring them again. And he told me not to call them seats on the phone anymore, to, call it hardware, and told me to replace them, and, all that. So he knew something was up. And he didn't want his goose to be cooked, so he kept those seats, which is probably one of the smartest things he could have done. But really interesting, right? So those will be two that I'm really excited to see.
3 contributors, with at least one of them being male. Assuming 3 contributors, the DNA profile from item 134S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. The results do not support the hypothesis that Fotis Dulos, Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos.
Yeah, they had dogs go back and they used her sweater as the scent in the park, and they didn't find anything.
Christiane Dulos, C. Noel Dulos, and Theodore Dulos are eliminated as contributors to the DNA profile from 134S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis or Lauren Almeida could be contributors to the DNA profile from item 134S1. Paolo Gumini is eliminated as a contributor to the DNA profile from item 134S1.
I'll be right back.
State Police Exhibit 371, which is identified as 4 swabs from the area with blood lice staining on the steering wheel, subsequently submitted to the Division of Scientific Services and designated as submission 135. What were the results of that analysis?
The results are consistent with the DNA profile from item 135S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis or Lauren Almeida, are contributors to this profile. Assuming 2 contributors, the sources of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis and Lauren Almeida are eliminated as contributors to the DNA profile from item 135S1. Fotis Dulos, Petros Dulos, Constantine Dulos, Christine Dulos, C. Noel Dulos, Theodore Dulos, and Pavel Gumeni are eliminated as contributors to the DNA profile from item 135S1.
State Police Exhibit 372, which was identified as 4 swabs from the interior side of the left front door, was submitted to the Division of Scientific Services as submission 136. And just with respect to these results, the results were consistent with a single individual, but every known profile along with the profile obtained from the toothbrush were eliminated. Is that correct?
That is correct, yes.
State Police Exhibit 373, which was identified as 2 swabs from the left front seat adjustment controls, was subsequently submitted to the Division of Scientific Services and designated as submission 137. Can you please indicate to the jury what the results were there?
The results are consistent with the DNA profile from item 137S1.
Kent was the friend who also got charged. That is friends with Fotis. That was his alibi originally, and was saying he was in the
1.3 billion times
meeting with him that morning.
If it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 137S1. Fotis Dulos, Michelle Troconis, Lauren Almeida, and Pavel Gumeni are eliminated as contributors to the DNA profile from item 137S1.
He was
State Police Exhibit 370.
He was Fotis's attorney in a civil thing like years before, but they had become friends. So he wasn't like his, current attorney for whatever. It was he had been his attorney before, but he wasn't like his criminal attorney or anything. It was for civil stuff from before.
Single individual. Assuming 1 individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush.
Yeah, Kent was also charged.
The results are inconclusive.
Conspiracy and everything. Same
as
charges
to whether
as Michelle.
the source of the DNA profile from the swabbing of the electric toothbrush, could be the source of the DNA profile from item 138S1.
And everyone else was eliminated, is that correct?
Yes.
And State Police Exhibit 375, which was identified as 2 swabs from the cargo area, rear seat controls, and subsequently submitted to the Division of Scientific Services and designated as submission 139. No profile was obtained,
Welcome.
Is that correct?
That is correct.
Welcome, O Cecilia.
Now, I wanted to talk to you about circumstances that can influence the presence or lack thereof of DNA. Could clothing or gloves or other objects in between a person and a surface impact the amount of DNA that is ultimately left on the surface?
If you're talking about from your hands,
So, for example, if somebody's wearing gloves, could that impact whether or not they leave DNA on a particular surface?
if they're touching something with gloves, correct. The gloves would interfere with leaving the touch cells from your hands.
Obviously.
And in terms of whether or not, let's just say hypothetically, blood or a blood-like substance is left on an object and that item is subsequently swiped with either a cloth or a paper towel, could that also influence the amount of DNA that's left behind?
Yes.
How so?
Well, if you use something to wipe up something and then throw it away, you're cleaning up some of that liquid or whatever it is, blood. So then you're losing some of that DNA that was there and just leaving behind remnants of it.
And does DNA degrade under certain conditions as well?
It does.
What does it mean when DNA degrades?
The DNA is breaking up and you're getting less of it. So if it's under the influence of ultraviolet light, bleach, moisture, heat, all different factors can degrade DNA over time.
If I could just have a moment, Your Honor. I have nothing additional, Judge.
Thank you. Cross-examination.
Good afternoon, Ms. Madel.
Good afternoon.
So I'm looking at your resume, which has been put into evidence. You have a degree in biology, right?
Yes.
So I'm going to ask some questions about, for those of us who didn't major in biology, okay? So when we're talking about DNA, we're talking about something that is transmitted. Everybody has DNA, correct?
Everybody's like...
every living thing has DNA, correct?
Yes.
Whether it's a plant, a bug, an animal,
radish.
or a human, right?
Yes.
At least when it comes to human beings, there are 2 sets of DNA that we inherit from our parents, correct?
Correct. Half from your mom and half from your dad.
So if we go back to basic biology, you have a mom and you have a dad, they have a child, and they inherit the DNA half from the father and half from the mother, right?
Correct.
And unless there's artificial insemination, you need 2 separate parents for that process to take place, right?
Correct.
And that within the DNA, there's something called alleles, correct?
Those are, yes, the specific types of the DNA profile.
And they're, for those of us who remember this from maybe high school biology, the DNA is kind of a double helix. It's sort of a twisty thing. That's how it's described. I think that's, if you use an electron microscope, that's how it'll appear, right?
It's like a twisted ladder or spiral staircase, yes.
And within that twisted ladder or spiral staircase, the alleles repeat at certain intervals, correct?
Correct.
And in any event, you're going to inherit half of your alleles from the male side, the dad, and half the alleles from the mom side, right?
Correct.
So one of the ways that these ancestry organizations work is they can trace your ancestry based on maybe a cheek swab or something, looking at other people in the database to see whether you're related to somebody else, right?
Correct, yes.
Because there'll be a lot of similarities.
Look, at least because we paused for a minute, now that he's up here, at least since we paused for, 3-4 minutes, whatever, we can listen to him in 1.25 speed now, so that it's funny though, as soon as he gets up there, everybody's like, here we go.
Between you and your parents and your children, right?
There could be, yes.
And in any event, if there are twins, whether they're identical or they're fraternal twins, they're at least close in, there'll be a lot of similar DNA, right?
There could be, yes.
So when you're running the
Look, Holly said, land the plane, sir. He's just now getting on the runway, and Holly's like, land it, we're over it.
This program, the STR Mix program, right? This is a proprietary program, right?
We do not know the source code. We know how it works, but we do not know the source code.
Right. In other words, it's a private company that has patented this calculation simulation, right?
She's a private company, yes.
So you're programming in information, right?
I put in the DNA profile.
And other information too, right?
Yes, I tell it how many number of contributors I believe it is.
Right. And I want to ask you about that. You put in a number of contributors that you believe or assume are in a mixture of DNA, right?
Based on my knowledge, training, experience looking at profiles, yes, I give my best estimate of how many contributors I believe that DNA profile is from the data.
And of course, that makes it more difficult when there's multiple contributors, right?
Sometimes it can, yes.
And in addition to that, if you have a very tiny sample that's only partial DNA, it's even more complicated, isn't it?
It can be, yes.
And some of the things when you talked about it, you said that it was inconclusive. Part of the reason was the sample wasn't even big enough to get enough alleles and repetition within a sample. Isn't that true?
Well, I'd have to know exactly what sample we're talking about.
Well, I'm using just in general. We went through a lot. Some of them, it was inconclusive because it was too small a sample for you to be able to derive a profile from it, right?
I think, yeah, I call those insufficient, I believe, when it's too small of an amount to make a comparison.
Okay. Well, you're using the word insufficient. Whether it's little or insufficient, it's just not enough sample for you to develop a profile of a person, right?
You're talking about two different conclusions, yes.
All right, well, fine, all right. Now, when it comes to what the lab does, you're not actually comparing the whole DNA to another person, are you?
I don't understand your question.
You're only choosing alleles from certain pinpointed locations along the double helix, right?
Well, 99% of everybody's DNA is the same, and we focus on this 1% that is most variable between individuals. And we use a kit that has a certain amount of sites that we do test. Yeah, so it's not every single site, but it's a representation of some of the alleles that vary.
And currently, the system you use has, I believe, 21?
Autosomals for statistics, global filer. Yes,
right, global filer, you take 21 points along the DNA strand to make a comparison, right?
21 autosomal sites, yeah, locus.
No, it's not a genome of that person or anybody, right?
It's not their whole genome, no.
Okay. And just for clarification, how many loci are there in a human DNA?
Oh, I don't know the answer to that.
Is it in the hundreds?
Well, the question really is, what is the range or an estimate generally? So overruled.
Give us an estimate.
I honestly really don't know if it's hundreds or thousands.
What was that number?
I honestly don't know if it's hundreds or thousands or how many loci.
It may be hundreds of thousands, right?
It could be. I honestly really do not know.
But we're only focusing on either 21 or maybe 23.
Okay. She said, I don't know if it's hundreds or thousands. And he's like, it could be hundreds of thousands, right? He's trying to up this number to create doubt. And she's sitting here saying, I don't know. But he keeps repeating this stuff, trying to make the jury hear, oh, that, it's so many and you're only focusing on one. So he's trying to create doubt on their conclusions. But I'm sorry, but when you hear it's 100 billion times more likely that this came from Fotis opposed to anybody else, that's going to be real hard to doubt.
Locations along the strand, right?
Very discriminating locations, yes.
And when you're looking at alleles, right, you're not just looking at what the specific allele is called, because they'll have numbers and letters, right?
Numbers.
But how often it repeats along a DNA strand, right?
Right, that number is how many times it's repeated.
And that's how you determine whether it's unique to a particular person or you can compare it to another person, right?
That's how I just determine the DNA profile, is by the number of repeats at each testing site.
And some of the alleles occur in a large percentage of the I'm using the word loci because loci basically means places, right, or pinpoints, right?
Those are the different sites that we're testing, yes.
Right. But I'm using the word loci so that the jury understands that word is a Latin term for location, basically. Mm-hmm. It's another way of saying that, right? Mm-hmm. Yes?
Yes, sorry.
Okay. So certain of the loci, for example, are only found in male DNA, right?
Yes, there are sites that we test that are only found on the Y chromosome.
And are there some that are only found in the X chromosome?
That would be mitochondrial DNA.
Okay. And you, according to your resume, had some experience in doing mitochondrial DNA testing, right?
I do, yes.
But we're not talking about that here, are we?
No.
Some of the DNA repeats. They're given actual numbers, either whole numbers or decimal partial numbers, right?
Correct.
And that's how you determine how often it's going to repeat on the DNA, correct?
In that specific location, that's how many times that length variation repeats, yes.
And if you look at one of your reports, there's a chart that's contained in many of them, right?
Correct. We used to produce an allele table with everybody's types on it.
And if it shows the numbers, those are any numbers you put on there showing how often something repeats in your sample, right?
At that specific site, yes.
And you're also looking at an unknown sample, the one that came in on a swab or on a piece of material or whatever else that you are taking to determine whether or not that DNA shows similar repetitions as one of the people you're testing against, right?
I am comparing the DNA types from a known profile to the DNA types of an evidentiary profile, yes.
And when you use the word during your direct examination a lot, assuming X or Y or assuming this or that, you made certain assumptions as to many of these samples before you then compared it to something else, right?
Correct. I determine the number of contributors in the evidentiary profiles before I compare them.
But you also, for some of them, assumed, let's say, that the person whose DNA was on the toothbrush, right, was one of the contributors to the sample, right?
In certain non-probative pieces of evidence, yes, we do that.
Well, you're using words like non-probative. You made the determination to use that regardless of whether you think it's probative or not, right?
No, we only can condition a known profile on an item if it's a non-probative comparison, typically a victim, that you would expect scientific expectation that the profile should be there. So like if my car gets stolen and it's recovered and they swab the steering wheel, you would expect my DNA profile to be on the steering wheel with anybody else who may have drove it. So if we would condition my DNA profile if it was truly there. If I looked at the results and saw my types there, I would condition my known in order to get the second contributor better explained.
So you're assuming, by that answer, you were assuming that your DNA would be on your steering wheel.
If looking at the data, it was there, yes. But looking at the data, I have to see my types there. I wouldn't just say I'm there. I would look at the data and see that my types are there.
But if you assumed that the contributor was someone else, whether it was a close family relative or not, it would change the likelihood ratios, wouldn't it?
Well, it would have to have a scientific
yes
expectation.
Or no, wouldn't it?
Well, to indicate to an expert what the expert's answer is, when an expert is qualified by education, knowledge, training, experience, and skill, is
ridiculous, stupid,
inappropriate.
unprofessional.
Secondly, the witness took an oath to tell the truth, whole truth, nothing but the truth. To tell the witness what the answer should be is inappropriate. You can move it to have it stricken as non-responsive. But this court does not permit counsel to tell a witness what their testimony should be.
Yes, Your Honor.
You can ask the question again.
Right. Let me rephrase the question. Regardless of whether I use the example of your steering wheel or not use any example whatsoever, the assumptions that you made about a contributor would, if you changed that assumption to a different known contributor, it would alter the likelihood ratio that would come out of the STR mix computer program, correct?
Again, it's hard to answer as a yes or no.
So it wouldn't change it? It would come out the same?
No, it could, but it all depends on the data and if that person is scientifically expected.
He's literally still trying to do exactly what the judge told him not to do. She's like, it's still not, can't give you a yes or no. He's like, so it wouldn't? Like, she just said, bro, that she can't give you an answer.
To, be on that profile, and their profile is there.
But once you run the program and you come up with a deconvolution report, on using STR mix. When you then test it against someone else, you don't go back and pretend you don't know who the source is. You start with what you've already, we'll call it deconvoluted, right?
You have one original deconvolution, yes.
Right. So when you add someone, you're starting with the likelihood ratios that the computer has spit out for you previously, right?
You don't get the likelihood ratios until you make a comparison to an individual.
But you don't do a full deconvolution analysis again over the same sample if you're running it against other people. Is that a fair statement?
I'm sorry, can you say it again?
Yeah. If you decide to check a sample, an unknown, against other people, you start with the report that was already developed from the STR mix computer printout previously, correct?
Correct, yes.
Okay. Let me just ask you some questions about some of the other things that came up on direct examination. A lot of the descriptions, both in the stipulation that we've entered into, the lawyers have entered into, and in your report, make reference to descriptions such as swabs from a blood-like stain, luminol plus whatever, KM plus. These are things that you mentioned. Those were how it came to you with a title on it, right?
Yes, that was how the submitting agency named that piece of evidence.
So you didn't label that this had was a blood-like stain, did you?
I did not, no.
The police called it that, right?
Yeah, whoever the submitting agency was, yes.
Same thing with if they said Castlemeyer KM plus, that's just the police writing that down on the sample that they put on the bag that they then submit to the lab, right?
Correct, yes.
Same thing with if they use luminol, that is just something they wrote on the bag, right?
I'm just going to object, Your Honor, at this point.
Right.
Can we have a brief sidebar?
Well, first, the nature of the questions are simply as the court understands them. This witness did not write the descriptions on the bags. And this witness has stated she did not write the descriptions on the bags.
Thank you.
So the court does not really see, unless there's a relevance objection, the necessity for a sidebar.
Well, may I be heard, Your Honor?
Yes.
I'm objecting because I think it mischaracterizes what happened. I think the question sort of assumes that the police are just writing these things as though no test was done. And I don't think that that's what the evidence is.
Well, that's essentially, in the court's view, an extraction from the questions. The questions appear to be very simple. There was information on the bag when you first saw them. That's how the court hears the question. So what is flowing from that, the court cannot contemplate, other than the fact that there was information on the bag and she did not write it. Overruled.
Am I correct? Was there something that was written on the description that you then note? You didn't change the description that the police put on it, correct?
No, we use what the police describe it as, so it continues through.
Right. You just give it your own letters and numbers to distinguish what you do from the exhibit and description that the police put on the back, right?
Yes, we have unique item numbers for our pieces of evidence under our case number.
Right. And I just want to be clear. You indicated that you're familiar with a little bit with Castlemeyer KM. Is that right?
I am, yes.
But you're not a biologist, right?
I'm a forensic scientist who I've had training on KM. I have a proficiency test twice a year in order to perform KM, so I can perform KM testing and have been trained.
I didn't want to interrupt. Did you finish your answer?
Yeah. Mm-hmm.
And
interrupt.
KM is not used. It's one of these presumptive tests, right?
We call it a screening test.
A screening test. It does not mean that a substance is blood, does it?
No, it just is testing to see if there could be the presence of blood.
There could be, but you're familiar with the fact that many other things test positive if you use KM on it, right?
Yes, other things can make a positive result.
And we're not just talking about animal blood, are we?
No, there's other plants and horseradish. There's a couple things that will make the test turn positive, but we're trained to swab things that are reddish brown in color and not just any swab.
But you made no determination as to whether or not any of these items yourself, you didn't determine whether they contain blood or not, did you?
I do believe that there are some items in here that we did do KM testing on at the lab.
Okay, can we just point out that if any of those samples were, let's say, horseradish, it wouldn't have Fotis DNA in it? Is that one of those things that we can make a stipulation for the jury that if she had tested horseradish would not contain Fotis DNA?
That would have been Christine Roy, but I have some of those results in my lab, in my reports.
No, I'm saying you personally did not.
No, me personally, no. All these evidence items went to forensic biology first, and they did all the testing.
And you know that you would not rely on a KM test to make a determination as to whether something actually was blood or not, would you?
No, KM testing cannot tell you that it's 100% blood.
Well, it can't even tell you if it's 99% blood, can it?
No.
Potatoes are one of those things that test positive, right?
I don't know definitely that. I know horseradish and some. We were trained to know that horseradish and some plant peroxidases do, but I mean.
And rust can too, right?
Rust is kind of tricky. Sometimes so when you do KM testing, you add that first colorless liquid, and rust makes it change pink then, versus you're not supposed to change pink until after you add the second solution. So rust is kind of like a false positive.
But anyway, rust, from your own personal knowledge, is kind of a reddish-brown color too, isn't it?
It is, yes.
But it wouldn't have DNA.
And you wouldn't say that it's scientifically reliable. That is, any reagent presumptive test is not reliable for finding blood, is it?
I would say the screening test is reliable for saying that it's KM positive and there's a chance that blood would be there, but we can't say that it was blood, no.
You're saying there's a chance that there is. My question is, you wouldn't testify that as a result of a KM test that something was in fact human blood, would you?
I would not, no.
We got to have fries to go with the burger. Obviously.
You're also aware that most of the items that you went through that you tested for were not even screened for whether there was actually blood or not through the biology portion of your labs. Is that correct?
Yeah, the ones that come in that are already labeled KM positive or luminol positive or even negative, we don't repeat that test because we do the same tests and we trust that the PD did their correct testing, and we wouldn't waste samples from the swabs to do that test again and take some of that sample that would then maybe not lead to a full DNA profile.
Ms. Madel, you're not in the biology department that does the testing for blood, are you?
I do know the protocols, though.
All right, but you're not in that department, right?
Forensic biology and DNA kind of are intertwined, and I'm trained on some evidence exam, and I'm competent on KM, so I'm not, but I'm majorly a part of the DNA unit.
And I just want to be clear, you would not testify under oath that something was in fact blood based solely on the fact that it was a positive KM test, would you?
No, I would not.
And when I asked you, most of the samples that we went through earlier through the state, we went through 100 maybe samples. I asked you whether or not most of them were not tested at the lab, and I don't think you answered that question. Am I correct that most of them were not tested with a confirmatory test for what it was, correct?
None of them were tested in these samples as confirmatory.
Earlier, when you were asked
what
are the sources of DNA, you made reference to blood. Let me just look at my notes here.
Squeeze my panda
blood,
stress ball.
Semen, I think you said hair, and you said bones, right? Didn't you leave out like the major source of DNA in that answer?
Blood, semen, saliva, bones, teeth, hair?
How about skin?
Cells, skin cells.
Skin cells, okay. Let's talk about skin cells.
Oh,
All of us have skin cells, right?
Yes.
And all of us have the same DNA in our skin cells that we do in our hair, in our blood, in our, shall we just say, our bodily fluids, right?
Correct, yes.
So you could take a cheek sample swab, right? And you would run a DNA profile on that cheek swab. You follow me so far, right?
Mm-hmm.
And it would be the same result for the DNA profile as if I took a sample of blood, right?
From the same person, yes.
Well, that's what I meant, from the same person. Okay. And when it comes to skin cells, for most people, they're shedding skin cells all the time, aren't they?
Yes.
And in fact, if you cough or sneeze, you're also through what they call aerosolization, right? You're expelling DNA that way too, aren't you?
Yes, that's possible, yes.
listen to this. Sorry. Focus, Brandi, focus.
When it comes to DNA, there's also something called primary transfer and secondary transfer. Is that correct?
Yes.
And I'm not sure you explained the distinction between those, but if we're talking about touch DNA, right, when you get a sample, does the biology forensic portion of your lab note on the file jacket whether something is touch DNA or some kind of fluid DNA?
They do.
And when you gave your testimony today, you did not distinguish between whether any of the samples that you tested and re-identified with the letters and numbers that we went through, whether they were touch DNA or something else, right?
Correct, I do not. I just test the evidence that they submit forward to me.
However it comes to you, you do a DNA profile, and then you run the test on that regardless of what the source is, right?
Yes.
And when there's a mixture, as you pointed out, of more than one source in a DNA, one might be from a liquid source and one might be touch DNA at the same time, right?
That is possible, yes. We can't distinguish where the DNA came from.
And if, for example, if I were to sneeze into my hand, as some people hopefully don't do, and then touch a doorknob,
Ew.
chances are that there might be a mixture of just me of both the skin DNA and maybe a liquid DNA on that doorknob, right?
That's possible, yes.
And then if someone else goes and touches that doorknob, they're not only going to maybe have a disgusting mess on their hand, maybe get some cold germs, but they're going to maybe get some of that transfer of the other person's DNA onto them. Is that right?
That's possible, yes.
All right. And then if I were to come over, or I don't have to use me, if that person was then to go over and shake someone else's hand, that's what secondary transfer is. If now my DNA or the first person's DNA is now on that hand of that second person, right?
That's possible, yes.
And that's regardless of whether someone's wearing gloves or not, right?
No, it can pick. If they touch a doorknob with gloves on and then touch something else with the gloves on, the DNA would be on the gloves.
The DNA could then transfer to that other person as well.
Correct, yes.
And to other surfaces that they then touch, right?
That is possible, yes.
And when you talk about, there were a couple of examples you gave where there may be 4 or even 5 contributors to a sample, right?
Sometimes we have 4 or 5, yes.
And it gets more complicated, more convoluted, if you will, to try and separate it out the more contributors you have, right?
And that's why we use star mix, yes.
Exactly, right? And then you're relying on star mix because it's just running this program to give you likelihoods of hypothesis A versus hypothesis B, right?
No, it's actually, star mix is giving us weights to best explain the different components that actually make up that mixture profile. That's what star mix is.
But what I'm trying to understand is it's not making a match to anybody, is it?
No, it's deconvoluting that mixture of 4 people to try and determine the best explanation of the 4 different people that are contributing to that 4%.
But in any event, the word is likelihood, not an actual. It's not identifying anyone, is it?
No, it doesn't identify anybody.
And when a report is inconclusive, I think you indicated, and you said it a few times, one of the ways that it's inconclusive is the sample is either too small for there to be enough allele locations to be able to be clear on who that person, who it might be connected with, correct?
I believe that's my insufficient conclusion, insufficient for comparison.
And inconclusive means either there's too many people that maybe have similar DNA, or it's just not enough points of reference to make a determination, right?
The inconclusive is when we do that likelihood ratio, and the likelihood ratio comes out to be in this range that is below a positive association, but above being eliminated. So
Right.
That's why we can't make a conclusion.
Right. And the danger, of course, with inconclusive is there can be false positives, and you could make mistakes if you try to subscribe an inconclusive result to anyone in particular, right?
Well, we just have that range that we say is inconclusive because it's not above what we deem positive.
Well, when you say it's a scientific level that's been established by the lab, right?
That it's not a positive association, correct?
And when you say someone is excluded, it's because there is an allele present that you know from the profile of the actual person is missing, or is missing completely, right?
Well, it's not just one allele, it's the profile overall.
Oh, I meant to say that if you count all of the alleles that you produce, even if it's more than one person, that the individual you're comparing it against is actually does not have that allele at all, right? That's how you eliminate somebody.
Not just from one allele. You have to look at the profile overall, the data, the number of contributors, the peak height. So it's a little bit more complicated than just not having one allele.
So other than in a couple of situations where there was inconclusive information, and I think you mentioned that every one of the people you mentioned had at least one inconclusive, right? Whether they were a contributor or not, right? All the children.
We're at least inconclusive once overall.
I'm trying to make a broad question. You went through 100. I could pull out the individual ones, but I'm just trying.
Yes,
there were some where all the children were at least on one occasion inconclusive, right?
Yes.
And in others, they were actually contributors.
Yes.
And then there's others where they were eliminated.
Yes.
And then there was a fourth category you said, where I think you said it cannot be eliminated, right?
Yes.
That was because it was a higher threshold than inconclusive, but less than identified as a contributor, right?
So the cannot be eliminated is a positive association that was just a terminology that we used to use, and we've currently changed the way we report that as consistent with a contributor, which I defined also, because it was confusing to people for us to say cannot be eliminated, because we were saying eliminated, but it was actually the opposite. You cannot be eliminated. So it's still a positive association. It's just the wording was a little different.
Yeah, but I want to be clear. When you say a positive association, it's below a threshold where you could testify that that person's DNA was actually present, correct?
No, it was a positive association. They were a match. They were a partial match, but they were a match and had a positive association.
When you say partial, you're again talking about that you could not testify that it was a match because it was only a partial identification or partial connection, right?
It was a partial match, but it had a positive likelihood ratio.
Again, that's the computer saying it's a likelihood ratio, right? Positive likelihood.
Well, we used Star Mix to calculate that because it would take us too long to do all those hand calculations.
And I take it you've never tried to mimic a SDR mix report by hand calculating out the odds, have you?
In my training, I only had to do it once.
Right.
Correct. I have not done it a million times. No.
A million times. No, and the machine runs odds a million times, doesn't it?
It has many iterations to try and describe the components of the profile, and then it calculates the likelihood ratio.
All right. Let me ask you a different question. Let me put it to a different way. The program runs what's known as an algorithm, right?
Correct.
That's the proprietary source code for SDR mix, right?
Within the mathematical process, yes.
And you don't know, you could not describe how that process actually, you don't know the code is what I'm trying to get at here. For that.
I do not know the code of the algorithm. No, I do not.
But these kind of programs that run these kind of likelihood of a certain result are similar to what's used by the lottery for calculating the odds of winning the Powerball, right?
I honestly do not know what kind of calculation they use for that.
Are you familiar with the term the Markov chain Monte Carlo?
Yes, that's the mathematical process used in Star Mix, yes.
Okay. Do you know why the word Monte Carlo is part of the name there?
Right, because it was originating from a gambling. Yes, but I didn't know that was used for the lottery.
All right. But, all right, so the gambling, though, right?
Yep.
You're talking about Monte Carlo as the capital in Monaco in Europe, which is a big gambling mecca, right?
Yes.
Oh, good.
And what they're doing is that kind of program calculates the odds of winning the jackpot on whatever gambling machine is being run with a giant jackpot, right? You don't know?
I guess, I don't know that.
All right. But if using that as an example, though, if two people, if the odds of winning the $1 billion Powerball, according to a program, an algorithm such as this, were 1 in 100 billion, right? Just assume for my hypothetical here. Does that mean if two people were to win it, that they were cheating?
That's different odds. You're saying 1 in 100 billion, where we're having the likelihood ratio with two competing hypotheses. So given my likelihood ratio is different than that.
And again, we're talking about hypotheses. Again, you're basing the hypothesis based on a prosecution's theory of a case, right?
No, we base it on the background information of a case and the actual profile itself.
Well, who
She is
decides on the
correcting him.
hypothesis? You or
I
someone
do,
else?
yes.
You make the determination
The
of
DNA
the
analyst,
hypothesis.
yes.
And
She's
you have to
correcting
read
him.
something about a case just to make that hypothesis, right?
You need background information on what the kind of case is, yes, and the pieces of evidence, yes.
Because otherwise, it's not like you're blindly taking a piece of evidence, putting it into a machine, and then coming up with a result without you having subjective input, right?
Correct.
Okay.
A juror is 100 billion times more likely to jump him in the hallway instead of saying, I love you. There's your 100 billion statistic. Get it together.
And just so that I'm clear, I'm going to go back to the issue of, you already testified that what the SGR mix is doing is not matching a sample to a particular person or two people or three. It's giving a likelihood of a ratio based on two hypotheses, right?
And how likely that evidence is to occur given hypothesis 1 compared to hypothesis 2.
And when you say likelihood, we're talking about odds, aren't we? Mathematical odds, correct?
Yes.
And so these odds are not based on population numbers either, are they?
No, it's not a frequency estimate, no.
So when we hear large numbers like 10 billion or 4 billion or 150 or 250,000 or 100 billion, we're not talking about other people on Earth, are we?
No, we're not.
Those numbers have nothing to do with populations, correct?
Correct.
Oh my God.
And when we talk about skin cell DNA, you refer to that as touch DNA, right?
So the forensic community is trying not to refer to some low-level DNA that might be collected from a surface as touch anymore, because we don't want to imply that someone actually did touch this counter and left their DNA. So we're calling it more trace DNA when it's small amounts recovered from an object or surface.
You are aware, though, that even at least at the time of 2019, the folder, some of the forensic folders from your lab still are using terms like touch in relation to this very case, right?
Well, yes, I mean, that's kind of also just for them to distinguish between when they have a piece of clothing that has bloody areas and then has non-bloody areas. They're just making that notation to say, like, I'm trying to avoid swabbing where the blood is, so this is an area that didn't appear to have a reddish-brown stain, so I swabbed it, the touch area, where something might have been touched versus having a body fluid on it.
And if somebody, for example, if I stay away from the word touch and instead use the term skin cells, that would be a better way to describe it, right?
Describe.
The word touch DNA.
Yes, I mean, touch DNA, yes. If you're saying someone touched something, you would get skin cells there, yes.
But if, let's say, I don't know, a police officer is walking through a house touching things, chances are that person's DNA might be found on those areas that were touched, right?
It could be, yes.
And if you have a result where you have unknown contributors to the DNA, it could be anybody who walked through that door who isn't separately tested to see if it belongs to them, right?
That's possible, yes.
Who told you to limit your DNA comparison to the children, to Lauren Almeida, to Fotis Dulos and Michelle Troconis, and Pavel Gumieni?
I only can make comparisons to the knowns that are submitted from the agencies. So that's what I do. When I get a known that's submitted by an agency, it gets processed, and that's who I make the comparisons to. I don't ask for additional knowns unless it's for an elimination known, like the situation for a stolen car. We get a swab of a steering wheel. It's a two-person mixture. I don't know if that person who owns the car is on there too, so I would ask for their known. But otherwise, I wouldn't ask for particular knowns unless there was a...
They use it as a way to
I don't think you were
set
asked
a
this by
narrative.
the state, so I just
Set of
want
questions.
to ask you this. When a swab is submitted to you, it's from some surface has been wiped. Let's set aside for a moment if an actual object or cloth, as you said, item of clothing or something is submitted. We're just talking about a swab.
Okay.
You have not observed how well or how poorly that swab has been administered, correct?
Yeah, if I did not make the cutting of the swab, I did not see it. Therefore, I don't know, what the swab looked like.
Do you get the actual cutting, or do you get the chemical or liquid that cutting of the swab was put into?
No, I get the actual swab in a tube.
But you get a snip off of, it's like a giant cotton tip applicator, right?
Did he just say a
So those of
snipple?
us who've had COVID testing know it's like these long sticks with a cotton tip at the end, right?
Correct, yes.
Bigger than a Q-tip that you might find in a hotel bathroom here, right?
So yeah, the forensic biologist would cut that swab, that cotton part off, and put it into a tube.
Put it in a tube, then it's given to you.
Correct.
And then you do something where you copy that sample. Is that right?
Well, first we extract it first, get the extract, then we see how much DNA we have, and then we make all those many copies so we can hopefully generate a DNA profile.
And at least as of 2019, when most of this, 2019 and 2020, when most of these comparisons were done, you were able to extract some DNA from as little as 3 cells, right?
I'd have to go back and look at my quant values for all this thing to testify that I did have something that was that small amount.
Is that are any of the reports up there for you to do that?
No.
Well, you used at the time, is it Fusion 6C?
Fusion 6C was the STR kit for 2019 and 20, yes.
And you would take a sample. These are tiny, tiny amounts, right?
There could be tiny, tiny amounts of DNA, yes.
And so the jury has some kind of semblance of size. One cell, as I understand it, is 6.6 picograms in, is that weight or size?
Weight,
Weight.
yes.
And so that we're clear, you've got grams, you have milligrams, you have nanograms, and you go down to picograms, right?
Correct.
And 1 picogram is a trillionth of a gram, right?
1 picogram.
You
Yes,
should know this
I
is
believe
math,
so.
right?
Yes.
You should know
Yep.
that. Am I right?
Yes.
Okay. So if you have one cell is 6.6 picograms, we're talking about 6.6 trillionths of a gram, right?
Yep.
And if you're not disagreeing that you can get a sample out of it, as little as 3 cells.
So 3 cells would be 18 picograms, approximately.
Well,
6.6 times
so
3, yes.
More like 20.
So
right?
20 picograms.
Okay.
You might get a few peaks. We target for fusion, we were targeting 500 picograms.
That's your goal.
To get a full, correct, yes.
But if you don't have that, you run the test anyway, right?
Correct, yes.
And that's how you get these partial results. Isn't that true?
That is true, yes.
And that's why in a lot of the places along the loci, it'll show NR, meaning no result.
No result is NR, yes.
So you then have just a partial DNA, and the machine is still trying to run the ratio, the likelihood ratio, against a partial DNA result, isn't it?
We could try and run a likelihood ratio of a partial, yes.
And doesn't STR mix actually add in, like presume, what if there was this extra allele in there? Isn't that part of its whole process?
The whole process is trying to explain what makes up that profile, yes, by how the PCR program works, which is the amplification process. It knows how it works. It is trying to use those, the word I'm looking for, use the way PCR works in order to come up with the best explanation for that profile, whether it be a full profile or a partial profile. It produces these individual components with weights to them.
So this isn't like AI, though, right? It's not artificial intelligence, but it's something like that, right?
No, we know how it works. We know the mathematical process that's being used, the MCMC, as you refer to, and the biological modeling of the PCR reaction. And it's doing all these iterations to best describe that DNA profile.
I understand, but getting back to what I was trying to say is, it is filling in. It says, what if the missing allele was X or 7 or 12, whatever, and then runs the program again to see if it was that, how would it come out in the likelihood? Isn't that part of the process?
Not to do with the likelihood ratio. It's doing all those weights first.
But it also assumes missing data, and it adds it in as a part of its probability, isn't it?
It's giving weight to possible explanations. So it does look at other things, but it's like a game of hot and cold. It's proposing this type to make up the profile, and if it is a hot or a good explanation, it goes towards that iteration. If it's not a good, it'll be a cold, and it will go in a different direction to try and best explain the different DNA types that are making up that profile. Right. And then those weights are used. Then, after it comes to a conclusion on what is the best explanation, then it uses those weights to calculate that likelihood ratio.
And so you're accepting the calculations from the program for your conclusions that you've told us about today, right?
Yes.
Right. When it comes to the sample, we talked about how little it could be. And just for reference, would a period on a daily newspaper be larger than the 20 picograms that we're talking about in terms of just being able to visualize it?
You can't visualize 20 picograms.
It's way microscopic, right?
Correct.
And the only way that you're able to even run this process is you do some kind of the equivalent of like photocopying the sample you have, right?
Correct.
So you have a process that's, not challenging, it's just established. So you sort of mimeograph, for those of us who are a little bit older, or you photocopy the data so you have enough to then run through your program, right?
We have enough so that we hopefully can develop a DNA profile.
Now, there's also a major and minor contributor to various samples if there's more than one contributor to a sample. Is that true?
Sometimes that can be determined, yes.
Who decides what those percentages of major and minor contributors is going to be?
Well, we can look at it as a DNA analyst and estimate, but when we run through star mix, it also gives a weight to what each contributor is contributing to that profile.
And again, this is calculating based on the quantity of what is now in the system based on your multiplication or photocopying of it. It's making it a larger sample, right?
Based on, yes, the number of contributors I'm calling it, and then the DNA profile result that we obtained, yes.
And when we're talking about major and minor contributors, if it's, 60 or 70%, and the other contributors are 20 and 30%, the person, let me rephrase that, the sample with the higher percentage is considered the major contributor, right?
That would be yes.
And that all the lower numbers are the minor contributors, right?
Yes, but sometimes you can't determine a major contributor and a minor contributor.
Well, when you say you can't, but can STR mix?
Well, STR mix doesn't ever call anything a major and a minor. It just gives you those percentages to make it to 100.
Do you ever disagree with its percentages? Are you able to recalculate that, saying this is wrong?
We do. That's one of the parameters that we do check to make sure star mix runs correctly.
So, Attorney Schoenhorn, if the next series of questions do not concern major and minor contributors, it's 3 o'clock.
That's correct. So I think this would be a good place to stop for the day.
Thank you. Ladies and gentlemen, we conclude the evidence for today. We suggest again that you would check the judicial branch website tomorrow, because the weather may be such that there may be a delayed opening. And we would ask that you please do not discuss the case, and have a good evening.
Oh, Lord have mercy. Everybody's like, oh, thank God. Yeah, I'm okay with him being done. That was a lot.
Could we off the record?
You may be excused.
Okay.
Thank you.
Off the record stuff? maybe we want to hear off the record stuff.
Cross-examination is expected to continue tomorrow for this witness, correct?
Yes.
And how long do you estimate on cross, Attorney General?
Good question.
15, 20 minutes?
Okay, thank you. And the state has a lineup for tomorrow? Okay, thank you. We'll stand adjourned until tomorrow morning, right now at 10 o'clock.
Could we start at 10:15 with the court's permission?
We can. So adjourned until tomorrow morning, 10:15.
Thank you.
All rise.
He sure is needy. He sure is needy. All right, let's get our last looks at her. We're about to go to Boston. I can say it. Okay. To watch our Karen Reed hearing. It hasn't started yet. But it will be starting in just a few minutes. So, all right. So, there wasn't a whole lot of anything that I think helped him or came from that. I get like some of the stuff that he was saying about some of the, going through the house. Like if somebody were to go through the house and touch different things and, you can't say who the other DNA profiles are. It could be anybody. Okay. That is true. Yes, sir. I will give you that. But also, Fotis was in there. Fotis was in there. Fotis is not a random dude in there. Fotis is Fotis, and Fotis was in there. So that's why some of that line of questioning is so frustrating, because it makes it so that you're like just waiting, like just pulling your hair out, waiting on him to finish with this ridiculous line of questioning. And you want her to, she did an awesome job. She did an awesome job answering. She was really smart. Even when he was trying to twist some of what she said. Woo! Loud.
You're going to like this. Tell me these are the best milkshakes.
Our businesses are. When do you have the president and she owns chocolate?
What flavor did you order? I got what we call home black and white, vanilla ice cream, chocolate cherry. M&M milkshake. Wow, nice. Need a little texture. Triple thick, man. Yeah. Cheers, Mr. President.
As it pertains to
random
any of these materials, pursuant to statutory, pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order in Panama was appropriate. Pursuant to the case law, I would ask that the motion be allowed.
All right, and just so we're clear, because you referenced it, I did receive, as you're all aware, correspondence from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. So with that, I'll hear from you now, Mr. Yannetti.
I appreciate that. Thank you, Your Honor. May it please the Court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order, I must
Just so it's clear, I have not seen those letters.
Okay. Still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into two parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case.
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are.
Right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Which part?
Well, this is the Commonwealth's motion, Your Honor.
Yeah, and your opposition, and I don't have from anyone. So, how about the second part of your argument, Mr. Yannetti?
Well, it does touch on that, Judge. The Commonwealth has revealed some of the contents of some of the letters, but I need to point out what they haven't revealed. And just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Yes, Your Honor.
If you're just going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
Lally. Blech. I like the zoom work by the cameraman. Oh. So this is, yeah, lunchbox. It's motions hearing. Karen Reed's attorneys want the federal investigators' letters to not be hidden from the public. Commonwealth wants them hidden. Yeah, on the Zoom is the defense. So it's their opposition to the letters, or to the Commonwealth. Is their their opposition to the keeping the letters from the public.
So, Mr. Yannetti, so far there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far I'm prepared to let you argue in general terms.
How does she not even have the letters?
With regard to that May 18th letter, Your Honor, that is not one that I will be.
Okay, that's why I brought it up. Okay, so.
Right. That's why I responded.
So you also not going to reference the response to that letter? June 1st?
Correct, yes. Yeah, those deal with the Office of Professional Responsibility.
Okay, I just have two more to just quickly take a look at.
Cool.
It's the letters between the Commonwealth, or the district attorney and the federal investigators.
All right, so I'd also like some time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them?
Well, I'm going to reference them in terms of a subject matter, but not the details.
So the letter dated August 3rd, 2023. Do you have that in front of you, Mr. Yannetti?
I do, Your Honor.
All
Yeah,
right,
she
so
said she didn't
the
get 'em
second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the...
Just when you're holding it, you can
See the light can see through it? Because I've got the print facing me.
You could see a portion of the print, that's all, just from the angle.
All right, thank you. All right, so with those parameters, Mr. Yannetti, I will let you reference the subject matter of the others.
Okay, that's fine, Your Honor. So in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product. It's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation.
Of course they don't
and finally, Category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI, asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There's nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is, it would not be effective at all, and in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like.
They won't side with
That
me, they never
hearing
do, but
will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters, and I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation. And, Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reeve defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled, under the Constitution and the Massachusetts Declaration of Rights, to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reeve. So, Your Honor, the because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right. Is there a response from the Commonwealth or no?
No, Your Honor.
Okay. All right. So I'll take this under advisement. I do need copies of these letters, so if Mr. McDermott can make copies and then hand them back to the Commonwealth. All right. So the second motion is the Commonwealth's motion for Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir. Hi. You can stand at the podium or counsel table, wherever you're comfortable. In a minute, I'm going to ask you your name, and I'm going to hear from you, but I do just want to state that I appreciate that today I did receive a response from Boston Magazine. I received there's a memorandum, there's a limited opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity to read it a short time before the hearing. But I do appreciate the response, and more importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, E-R-T-S-C-H-E.
Okay. All right. Could you tell...
I'm representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right, so there is the Commonwealth filed a Rule 17 motion.
So Gretchen Voss is the one who wrote the article in Boston Magazine, and she was in contact with Coffin Daffer. Shocker! Coffin Daffer was one of her inside sources for all the whatever she thinks she's an inside source for. So this is about the motion from Boston Magazine and Gretchen Voss, that reporter, about the notes from an off-the-record interview.
You, as the third party or the record holder, have a right to be heard, so I'll hear you.
Thank you, Your Honor. There are really three documents at issue. Two recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you explain that, please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is an interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
So Commonwealth wants access
The
to that.
argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2,
Okay.
because it really is just a fishing expedition.
100%.
The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Where counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And and she says, that these are, she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a goldmine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape. Body language, physical reaction to a question, the same thing. These being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers.
I want to say one thing, too. When he's talking about this being a fishing expedition, the Commonwealth is literally trying to get anything that they can about notes about interviews like that she did off the record with her at the house where it wasn't recorded. It's just her taking notes about them talking. And, she used that as, like stuff that he said she didn't put any statements from Karen in there. But all of this stuff is them looking for anything that they can find, to try to use against her, because I don't think they have enough. And most people share, in my opinion. The people who don't are super, super hateful. And, I get attacked for saying it, God forbid. But I've been attacked more on this case. I was called a CUNT, last night or the night before? Because I said that I had hopes that, something that was being organized to honor the victim by people who believe that Karen Reed is innocent. I said that I had high hopes for it and thought it was a great way to remind everybody who the victim is, and I was called a CUNT. So I the amount of aggression in this is ridiculous, but also the whole point here with him saying this is a fishing expedition. If she grants the Commonwealth's motion to get all of Boston Magazine and Gretchen Voss's notes and everything for this fishing expedition, I'm going to be really pissed, because the whole fishing expedition thing, she wouldn't grant, actual witnesses who were there. She wouldn't grant, information from their phones, for the defense. And she said that, that's a fishing expedition, and she, sided with Commonwealth on that. So if she sides with Commonwealth on this too, it's just going to show how much she always sides with Commonwealth.
With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation to say that this balancing requires balancing between A, the public interest in having every person's evidence, against B, the public interest in the free flow of information, which can be implicated by needless disclosure of sources or confidential information. In that case, Doe affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's Commonwealth against Doe, 410 Mass at 602. There's also the Commonwealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. And those two cases, I'd say, are exactly on point. Now, here, has to some extent performed her own balancing test, and after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel.
I think that's very fair.
I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements. And as set out in her affidavit, production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news-gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's an additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules, 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So, in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio-recorded interviews. The Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction needed. I'm not quite sure how that gets conducted.
Okay.
But within 2 weeks,
okay,
possibly less if necessary.
All right. All right, I'll hear the Commonwealth, and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you. Your Honor, the nature or the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument the Commonwealth would submit is speculative at best. I would refer the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here the source itself is not confidential. So we're not talking about a confidential source. We're talking about potentially confidential information. But the notably what's cited to are federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion in submissions that there is not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition. To cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. For 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible, and that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17, would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that third. I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first 2 recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
What do you say about that, Mr. Burson?
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said because Ms. Voss does not oppose the release of the 2 interviews, save the off-the-record portions of the lawyer.
I think he's talking about the 3rd interview.
Yes, but I'd also refer to any part of the first 2 interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth will be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize a common law privilege. They do. They recognize an evolving privilege that's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test, and it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Yeah.
Okay.
I agree.
Thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in. And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me. I am concerned about the safety of the reporter. She shouldn't have to suffer harassment or any danger as a result of this.
Of course not, Your Honor.
All right.
Counsel,
So,
is February 1st, which is 2 weeks from today, is that doable? That's doable.
okay. All right. Thank you. So, Ms. Giannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks.
It's crazy how kindly she talks to people other than defense.
Jim, can you suggest a date?
It's like she doesn't even try to hide it.
How about...
May I interject, Your Honor, with regard to a date? I know that our final pretrial is February 15th. Our request will
February
be
15th? I thought it was February 26th.
We have two.
Okay.
We have February 15th and February 26th.
Okay.
So you're both right.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15th. And I'll tell you why, Your Honor. One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience they can't allow this case to go to
Did
trial.
they give you a date, Ms. Giannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is... it's at 9 o'clock.
All right. Assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
The only issue there is that
Nobody
do have
cares,
a trial
Zoe.
before Your Honor that's scheduled for February 13th. So,
Right, that's the case that I expect we'll be on trial for. And if that's the case, we have to finish that. We've got a very busy trial schedule. So if we're on trial, we'll see you at 2 o'clock. All right, so stay in touch with Mr. McDermott. All right, is that it for today then?
that's it for the Commonwealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
Okay. All right, and Mr. Birchie, I appreciate you being here, sir. All right, hearing's over. Jim?
Thank you. February 15th.
Okay. Goodbye. Tori, thank you. I am going to take my computer and
Goodbye.
you can. Thank you so much. That's my good hand too, Jen. Oh, are these my copies? No, I didn't give them. They are? And did you give Adams back? Thank you. Tori, thank you very much.
When she pretends to be nice, it drives
Thanks,
me nuts.
Soraya.
She's so rude to defense attorneys because she's very obviously biased. She doesn't even try to hide it. Does not even try to hide it. Yes, I have done a where did that question go? I have done a podcast on this, and I was putting out pretty regular episodes every week and a half until I got sick. But and I've had to deal with some health stuff. But I think I have like 5 episodes out. So the majority of the information that led up to the time is out. If you go to my main YouTube, like the main YouTube page, there's a playlist, Conspiracy in Canton, and it does the deep dive on it. So here's my thing on this. Here's my thing on the whole Karen Reed situation. My problem is that I'm not going to say that I know what happened. There are some people who are very, very sure that, that she did it and she's, so terrible. And then there are some people who are very, very sure that, that the defense's theory is the right theory and that's, all there is to it. And that's, there's no question to it. People on both sides are convinced 100% that they are right and the other side is wrong. I am not one of those people. I am not saying that I think I know 100% what happened. I don't. What I will say is there is no possible way that any reasonable person who is not basing their opinion on how much they hate somebody else or hate another side or whatever, there is no possible way that you can look at this information that has been released along with the corruption involved, the conflict involved, and all of the details. There is no way possible you can be a rational person and look at that and say that she is guilty beyond a reasonable doubt. No possible way. There are people out there who say it. That's why I get called names. There are people out there, like on both sides, who are rude, hateful, irrational, unreasonable, illogical, and assholes on both sides. And that's frustrating because this is not like, one of my biggest things is I like to be able to, like, it doesn't matter if we don't agree on what's happening. We should be able to talk about both sides rationally and have a conversation. Not on this case, Buster. I'm going to tell you right now, that is not the case on this. I had no idea the amount of vitriol that would come at me based on this, and other people as well. one of the people who really, I've said before, like I call him like the loudest person in the room, is Turtle Boy. He's a blogger who really kind of, blew this up. He is, and I say he's the loudest in the room because he is. He's one of the ones that he just, took it and ran with it. He also had a lot of, there's a lot of people that really dislike him. His methods of how he does things are not what I do. It's not how I approach things. But so many people hate him so much that they automatically think that whatever theory he has, which is the defense's theory, is automatically wrong. And they care more about Turtle Boy being wrong than they do about actual justice or facts. And that's frustrating. There are people who, when they hear me question anything and point out all the issues in this case, they'll automatically, be like, oh, you're just a, mindless minion of Turtle Boy and, all this stuff. I didn't even, and because he heard the podcast and he had said on multiple of his streams or whatever that it was, really well done and everything. And so people heard, him saying that my podcast was good, and now they have, because they hate him, made me also an enemy. But that's what's frustrating, is that my podcast, my research is mine. That's what I've done. That's my baby. That's my work. That's my hours and hours and hours and hours of research and comparing things and going over documents and doing, FOIA requests, and that's mine, not anybody else's. But when I say people are irrational and illogical in this case, they don't care. They don't care that it's my work. They just automatically, if I'm asking questions that don't make sense, they want to shut it down. And that gets really frustrating. It gets really frustrating. I think that that's the biggest issues with the people paying attention to it. The biggest issues with the case itself are, really, honestly, pretty much everything. Pretty much everything is a problem. Everything is a problem. If you're not familiar with it and you haven't listened to my podcast, I recommend it. I have, like I said, I've spent hours and hours and hours and hours and hours of work on this. And there are people who have, posted on this who I agree with some of what they say, and some of it I'm like, nope, don't agree there. There are some that, I don't agree with anything, and there are some that I probably agree with everything. But regardless, this is one of those where there's so much involved. I don't care who you agree with on what. You cannot look at some of this stuff, and if you are actually being objective in it and not emotional, you cannot look at some of this stuff and be like, yeah, that's okay. And the people who do, I know it's because they have, chosen a side and they have confirmation bias. So the only things that they will support are their side. My thing is, I don't have a side on what I think happened. But also, the Commonwealth has been dirty. They're getting federal investigation right now, ongoing. You just heard it, confirmed. Ongoing federal investigation. They did not record any of the, interviews that they did. They found a dead Boston cop on another Boston cop's, in another Boston cop's yard, and didn't even go in the house or talk to him. Didn't even do, any kind of, the investigation is a freaking joke. They have all of these undocumented searches. They have, all of a sudden, the day that they're there, they used a blower to melt all the snow, and there's no taillight pieces. And then it snows all day, one of the worst blizzards that Boston's ever seen. It's in the top 10 blizzards Boston's ever seen. Then they go back now not only is daylight gone, but there's all the snow, and then all of a sudden they find taillight pieces. Again, that doesn't make sense to me. There's people who are involved with each other in the case, and have links to the people who are the homeowners where he was found, are the ones that, like, the lead investigator is, and they deny it. They try to deny it, but which is also lies. We've seen it. We know. They think we're stupid. We're not. And you'll still see people like, that's been proven. It's not true. That's bullshit. It's bullshit. And if they tell you that, they're lying to you. They're lying. They are lying. And that's what makes me the maddest, because people will tell you that one side is lying. They'll tell you that the defense is lying and that it's propaganda. Somebody said that they wouldn't do a geofence. When they did the request for the geofence, they did the geofence request only for, the defense wanted a geofence to see who was in the house. So they put in the geofence request, right? But they left out anything from Apple. So somebody put out a tweet saying that's just, that's something that we picked up on, defense picked up on it. It's like, you didn't ask for, Apple information. They all had iPhones and you didn't ask for Apple information. So they put in another request. Lally puts in another request. And instead of getting the automatic email confirmation that the request has been submitted like they did the first one, they didn't get it. So they asked for it, and what's he do? He gives them just another copy of the first one. He never submitted it. He didn't submit it. So they're asking for Apple. So this is one of the main points that gets talked about. Like, why aren't you asking for this? Why aren't you getting this for us? So somebody said, oh, that's, propaganda, that Apple doesn't even do geofences. Yes, you are absolutely correct. Apple does not do geofences. That's not what the request was for. But that's the kind of stuff that it is. Like, people are, that post said that it's just defense propaganda and everybody's falling for it. And then people start sharing it because it goes with what they say. But if you actually look into it, that's not what it is. The geofence request was to Google, not to Apple. Apple won't do them. It was to Google asking for things from the Apple iStore. I have an Apple phone. I have Google Maps on my phone. Google Maps is not an Apple thing. It's a Google thing. So if they subpoena Google for Google Maps that have been downloaded from the Google Play Store, that is going to be only people that don't have iPhones, right? But if they include Google Maps or any applications from Google that are downloaded from iTunes or the Apple Store or whatever it's called, then all of a sudden now you have the information from iPhones too. That's what they won't give them. That's what they won't do it. But if people took the time to actually read and research and find out what the hell this stuff is, they would stop spreading all the misinformation. And that's what frustrates me the most. It's just, I get so mad because if Karen Reed is guilty, Karen Reed needs to go to jail. If Karen Reed is not guilty, Karen Reed doesn't need to go to jail. But whatever happens, if this is not done in a way that is above board and done the right way, no matter what, it's not going to be justice. You cannot have dirty justice. It needs to be done the right way. Justice for John O'Keefe died a terrible death. Horrible. And from everybody that's said anything about him, everybody says, like, he was such a good dude. He doesn't deserve to have the lying and the misrepresenting stuff and the fighting and all of this stuff. He doesn't deserve to have any of that. Justice for John O'Keefe is not just getting Karen Reed in jail. Justice for John O'Keefe is finding the person responsible, being honest about everything that's going on, and then putting the correct person in jail. If Karen Reed is not the correct person, or if there's not enough evidence to convict her, that's not justice. I get so mad. I get so mad. Justice is not just, let's throw somebody in jail. Justice is finding the truth. And that's not something that has been important in this case. You know, I'm not surprised that there is a federal investigation of the Commonwealth. I'm not surprised that Unetti said today that whatever comes out in it is going to embarrass the Commonwealth. They should be embarrassed. They have done a lot of really embarrassing things. You know, and I've talked about some of that stuff already. It's so frustrating to see the bullshit that they put out there, and it's frustrating to see the bias from the judge, and that's my personal opinion. That part's opinion. A lot of people share that opinion. Some people don't. My opinion. It's really frustrating to watch. And at the absolute bare minimum, there is reasonable doubt. You cannot go around, Coffin Daffer, I'm talking to you. You cannot go around convicting somebody when at bare minimum, there is reasonable doubt. She is innocent unless proven guilty. And when you have somebody who, this is why to this day, Coffin Daffer is the only person I've ever cussed out on the internet. I finally lost my shit when she kept coming after me. But I think it's so irresponsible to use a large platform and people who trust you and what you're saying to convict somebody in the public eye without there being enough evidence to convict them. She is innocent unless proven guilty. And when you have people who are going as hard for her, this is not one of those things like, you know, like Thami, where we were talking about it going into the case, but we already had all the information from the previous case. You know, this isn't one of those. This is Karen Reed's innocent unless proven guilty. And, you know, people making jokes on the internet about how she's going to get sexually assaulted in prison and stuff. I mean, what the hell is that? How is that justice? How is that something that we joke about? And more importantly, how are you going to clutch your pearls when other people on the other side say things that you think are so bad, but then you're going to say stuff like that? It's hypocritical. I hate it. You can tell that I feel very strongly about this case, can't you? I feel very strongly about it. It's one of the ones that I do not pretend to know what happened, but I have a lot of questions. And the thing is, y'all know I want to see justice for a victim. The problem is, if Karen Reed, hypothetically, if she were guilty, you have a large population of people who will never believe it now. They will never believe it because you don't have a prosecution who acts so dirty if they have enough evidence to convict somebody without it. If they truly had enough on her, they wouldn't have to be so dirty about things. There wouldn't be changed police reports. They changed police report. Didn't tell defense. They did interviews, and the stories change in the interviews. We don't know if it's the police changing the stories in the interviews or if it's the people who were interviewed telling the stories because they didn't even bother to record it. It's frustrating. If she's guilty, you have a whole big old group of folks who will never believe it because all they're going to see is a dirty Commonwealth and a dirty DA. And once the Commonwealth and the DA have lost credibility, you don't believe anything they say. So that will be on the 15th. The hearing to dismiss and to have the district attorney's office removed. That'll be interesting. That'll be really interesting. Don't know if it'll happen. Judge never goes with the defense, ever. But it'll be interesting to see how that plays out. So, interesting. Nurse for God, I love you. Thank you for gifting 10 memberships. Thank you. Y'all are the best. Don't get me started on Wendy. What the heck is wrong with that lady? How is she allowed back on? What is wrong with people? She's one of the ones that made a joke about her getting about Karen getting sexually assaulted in prison, which Wendy is supposed to be like a victim's advocate or something, or like a attorney that's, don't quote me on this, something about an attorney that works with victims of sexual assault or something in that area. And she made that joke. Done. Blocked her. Don't ever want to see anything she has to say. Like, how is that even okay? What? Ridiculous. Yeah, change police reports. Yep. It's crazy. Nancy D, thank you so much for Super Chat. Strong Brandi, we loved you. Thank you. Yeah, read up on it. I did the podcast. Y'all could listen to the podcast. I've gone over, like all of the court documents and stuff like that. I talked to, when it came to like the phone stuff, I talked to an actual phone programmer person or whatever, to find out how for sure that the search happened at, for how long to die in the cold happened at, before they found the body, like stuff like that. Like I put a lot of research into it, to just question everything. And nothing makes sense. So nothing makes sense. Let's see. Delphi ruling. Somebody said earlier the Delphi ruling was that they did not take death penalty off the table, so now he has to get a new attorney who is DP qualified, right? I think that's everything I heard. More charges for Richard Allen in Delphi filed half an hour before Supreme Court hearing. Oh, wow. Betsy Jean, yes, I do get very passionate. I get passionate about stuff that I feel like is not fair for people. When people are being victimized, I get really passionate about it. Yay, Judge Gold not removed though. Let's see. Did I get caught up? EDB has now picked up on the shadiness of the prosecution's case. It's hard not to. Once you start going through the documents, it's hard not to. Nurse for God, thank you so much for Super Chat. You go, girl. We love you. Thank you. I get passionate. And I like facts. All right. I guess we're done early for the day. That's one of the perks of speed trialing too. We started late, and since they left early, Okay, this is controversial. This is very controversial. One of my friends sent me some information about Scott Peterson. She's a digger like I am, likes to dig into the nitty-gritty. And she said, this was last year, and she sent me information, and she said, Scott Peterson is innocent. And I told her she's crazy, but that's cute. And she sent me information, and I started looking. And I'm going to tell you that I have not finished looking through everything, but from the stuff I've seen, I think he might be. Now, I will tell you, it is a huge deal for me to say that because I named my child. My child's middle name is named after their unborn baby that they never got to have. When I was pregnant with my son, I had already picked out his first name, and I didn't know what I wanted his middle name to be yet. And when I heard about Scott and Lacey Peterson and their unborn baby Connor, I thought that was just it broke me. I mean, I've always been into true crime, so of course I followed it and everything, but it broke me, and I was so sad about that. And I was like, oh my gosh, I cannot believe, like, that's so sad. Like, and her smile just lit up. Like, she's just, it was heartbreaking. And so I literally named my child after Scott and Lacey Peterson's baby. And so for me to say, based on other things that I have seen, I think he actually might be innocent now is a huge deal for me, because here I am living, 20 years of my life, having my kid named after her kid. So, the stuff that I have seen that has changed my mind was stuff that was not allowed to come in. The pretrial motions and the information and stuff that was not allowed to come in is what changed my mind. And I should do a video on that. You know what? Maybe I'll do that. Maybe I'll do a video on that. I'll have to pull everything up. I have it on my laptop. I don't have it on this because my friend sent it to me and I downloaded it all on my laptop. So I don't have it on my computer, or I'd show you, but maybe I'll do a video on that. Tina said, it's going to take a lot of new evidence to change my mind. Yeah. I'm telling you, it took a lot of evidence to change my mind. And there's a lot of stuff. And I'm sure I'm going to get some people that are like, I can't believe you said this. Yeah, I agree. I'm one of those people. It's like, I can't believe you're saying this. You see, this is why making trials public is critical. Exactly. And the hearings, because the stuff that changed my mind isn't even stuff that was in the trial. It's stuff in the pretrial motions in the hearings. And that's what changed my mind. I'll do a video on that. I'll put that together, actually. I think that's a good idea. I did not know Innocence Project had picked him up, but I'm actually not surprised, because within the past year of me starting to really dig into that, I've changed my mind too. I've changed my mind. I'm not saying I'm like, he's 100% innocent, but I'm saying I wouldn't have convicted him. If I'd heard everything that was in the pretrial motions that didn't come in, I wouldn't have convicted him. No way. No way. Oh, wow. Concord just released a man for wrongful imprisonment after 30 years. Paid him millions of dollars. It's very sad. Isn't that crazy? Like, could you imagine spending that much time behind bars? And it happens, like, more than, more than we even see. Like you see, what's that show? Is it Innocence Files? Is that what it's called? Innocence Files on Netflix, where it's got like all the wrongfully convicted stuff. And I mean, you see like different documentaries and stuff like that sometimes, like randomly. But there's a show, I think it's called Innocence Files or something. Watch that, man. It will scare you to death. Scare you to death. So, oh, just happened today. See, I guess that's why I hadn't heard about it, but, one of the Central Park Five was just elected to office in New York City. Wow. It's hard to say how a jury would have voted with that evidence. At that time versus now, 20 years later. Yeah, so many convictions have been overturned when they were based on eyewitness testimony. It's really hard to identify someone you only see for a brief second. Yeah. Did you see the one that was recent? They released somebody I saw, I don't know the details of it, but I just remember seeing this side by side. They had the first, him and the guy who did however many years, a bunch of years, and another guy looked just alike. And they had like the same style beard, same style like hair, and their first name was the same. And one of them was convicted for like armed robbery or something and did like, I don't even know how many years. And they were locked up together. So the guy who they identified as this one guy and were like, yep, that's him, lock him up. He's locked up, didn't do it. Then the guy who actually did it gets locked up for something else, and they're locked up together. And then it turns out he's like, oh, you're locked up for that? Hey, I did that. Isn't that crazy? Crazy. Let's see. If you might see that their pictures floating around the internet. It's crazy how much they look alike, those two people. Oh, EDB is Emily D. Baker. She's awesome. Yeah, I think that's a good point, Stephanie. Like the eyewitness, if you know the person, is different, because I can look at somebody and be like, oh, that's Mr. Bill from next door, or that's, like if you know the person. But when you don't know them and you're having to rely on your memory, I think it's super tricky. And that, what's that? I think it's a documentary on Hulu. Outcry. Same thing. Mistaken identity. Two guys looked real similar. And the kid ID'd the wrong one or whatever. But then if you look at and it happened like when they were like either in high school or fresh out of high school, I don't remember. But when you show their high school pictures of them when they were whatever age they were when this happened, looked just like I mean, you wouldn't have been able to tell them apart. Isn't that crazy? All right, let's see what else we got. I'm going to end early today. Me and my kid are going to see a movie tonight. They're doing, since we have so much damage here from tornadoes and stuff, our movie theater is doing $5 movies for the rest of the month. So we're going to go see a movie. Spend some time with my kid. I'll probably end up falling asleep, but that's all right. Oh my gosh, yes. The dude, oh, let's see. We watched for a class, it's moving. I think it's what we watched, blah, 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 blah. I think is what it was called. We watched for a class, dude got out because they had film of him at a baseball game at the time of Crazy. They were filming, what's that show? Not Seinfeld, but it's the creators of Seinfeld. What's his name? Larry? Did I make up Larry? Maybe it's not Larry. What's that show? He has the glasses. Hold on. I gotta Google it. Now it's gonna drive me crazy. Larry David. Yes. Larry David. Whatever show he does. What's the name of it? Or is it just called Larry David? I don't know. Larry David was filming an episode at a baseball game. And a guy who somebody had said, they said he did something. I can't remember what it was. It's been a while since I've seen this. Curb Your Enthusiasm. Yes. Y'all are so good. A guy that was arrested, or they were trying to arrest him or whatever for whatever crime it was. Larry David happened to be at this ball field that day filming an episode of Curb Your Enthusiasm. And they filmed an episode where he was like at the top of the stands and he was going to walk down to his seat or whatever. And this guy who was getting like accused of whatever crime this was, I think it was, wasn't it like a drive-by or something? I can't remember. But this guy who was getting accused of it was like, no, I was at the game. They were able to pull the video from that episode of Curb Your Enthusiasm and see him walking to get refreshments, like walking to the, going to get him a hot dog and, Coca-Cola, and were able to prove his alibi because they just happened to be filming. Isn't that crazy? Like, what are the odds? Lucky for him. Lucky for him. Can we get on with what? What is it you would like to get on with? Because we're done. Is there something else that I should be talking about? Get on with what? What are we getting on with? I'll get on with whatever I want to talk about. This is our time. This is my time. They had the footage that day. It was nuts. How crazy is that? How lucky is he? I mean, I guess not lucky because you got accused of a crime. But, like, how crazy is that? Some of that stuff is just, so interesting to me. But yeah, I think is it on Netflix, y'all? I think it's Netflix. But it's like a short documentary. I recommend it. It's really cool. Alrighty. I am, so lucky in a way. Not to get, not like, I guess getting accused of a crime is not lucky, but just lucky that he was able to get that footage. So, Scott Peterson is guilty. Only reason he got this is because of his sister-in-law. I disagree. Innocence Project doesn't take on cases as favors. They take on cases that they believe they can win. I'm telling y'all, wait till it all comes out. All right, y'all. I am going to get out of here. We are going to start, we'll do 12 o'clock tomorrow again. 12 o'clock worked pretty well for us today. They may start court later tomorrow, they said, based on the weather. So even if they do, we will keep an eye on it. If they start later, then we might just be in real time. But if not, then, you know, hopefully they don't start late, because then we can speed trial again. I love the speed trialing. Love the speed trialing. Love it. Yeah, it's very hard to be picked by Innocence Project. Very, very hard. There's a very intense process to get picked. They only take very few cases, and most of the cases that they take, unless they have like DNA evidence or something like that, a lot of times they won't even take it. In order to get picked by them, they have to truly believe that they are going to use all of their resources and all the money it costs, because they believe that they can win it. So very interesting. Oh yes, it's called the long shot. Long shot. That's what it's called. Yes, Dino 420. Yes, thank you. That's what it's called. Long shot. The one of where he was filmed at the ball field. So, crazy. That means there's a killer out there if Scott didn't do it. It was, from what I have read, not just one. I think it was like multiple of them together. So interesting. It's interesting stuff, y'all. I'm telling you. Oh, Future found it for us. Thank you, Future. Thank you. All right. I am going to get out of here, y'all. I appreciate it. I will see you tomorrow at noon. And we will, I need to watch Scott Peterson again. Maybe that'll be something we do in between, trials. Not that we have an in between trials for a while, but maybe that's something we'll look at. Be Kind Tiger. Be Kind Tiger, thank you so much. We all want to know how to give 5 stars to your podcast, please. Oh, if you go on Apple Podcasts, there's a place where you can review it. I don't remember how. Let me see. It's Apple Podcast, and it's 13th Juror Podcast. And I think if you, let's see. I don't know how to do this stuff. Oh yeah, here we go. So if you go to the 13 Juror Podcast page, and then you scroll down right here, there's a place for 5-star reviews right there. I have, I've gotten mostly 5-star reviews, except for the 2 that Coffin Daffer gave me. All right. Thank y'all so much. I appreciate it. 12 Eastern tomorrow. 12 Eastern tomorrow. Oh yeah. Most other podcast platforms too. It's on everything, not just Apple. It's on everything. Spotify. I can't remember what else. Whatever else there are. Yeah. It's on Spotify. It's on all that stuff. Pretty much anywhere you get podcasts, it's on there. All right, y'all. I will see you tomorrow at 12 Eastern. Be good.